instructs the Speaker to establish a committee for the fact-finding mission. Now, this committee, in terms of the judgment, needs to be constituted in terms of specific rules, and its mandate must be spelled out clearly as well. Because these were the things that were raised by the court to say your ad hoc committee system does not have this, so therefore your system is not sufficient to deal with the Section 89 motion. So we need to have that in the rules to say what's the structure of the committee, what's its size, what's its party representation, how is it going to take a decision to make that recommendation. That came out as well in the judgment. It appears that there was, and I must watch my words here, there was a reference to what we know as the Mazibuko case. The Mazibuko case deals with the motion of no confidence, but that motion of no confidence didn't reach the Assembly because in the programming committee, it didn't pass a certain level of consensus. So the court, the majority at least, was very concerned that in this preliminary phase, in the predetermined phase, that the whole Section 89 process stops there. So what we need to ensure in the rules is that the process will continue to reach the Assembly. So in other words, even if the majority in a committee decides, but this was not a serious violation, I'm going to say something about the serious violation of the Constitution as well. If the majority decides it wasn't, that report still needs to be debated in the House. It's almost as we go back to the Ambrosini judgment to say when there's a member's bill, that although the committee decides that the member's bill should not proceed, it must still be debated in the House because that is where the public gets an opportunity to see what's going on, and that's the whole purpose of having a parliament. So I think the principle there is it must be sure that and Chair, if I can refer members to paragraph 232 of the Chief Justice's judgment. Although he was in the minority, he summarizes the majority judgment there, and he sets out the principles in paragraph 232. He says it must not use the numerical strength to frustrate the tabling and debating of impeachment motions in order to shield the president who is their leader. So I think I've said enough about that. And then, of course, the purpose, the inquiry of the committee should be spelled out in the rules. So, Chair, what the majority said to Parliament is to say you do not have rules, you must have specific rules. What you have at the moment is insufficient, and you have to do this within a reasonable time. And there's correctly some confusion about the timelines. It appears, and we don't see it in the majority judgment, that there were timelines spelled out, 120 days and 180 days. The reference is made in the Chief Justice's judgment on that, and of course in the media summary. But somewhere along the line, the majority judgment must have taken it to heart and removed the specific timelines and just referred to Section 237 of the Constitution that it says that it must be done without delay. Now, well, without delay means as soon as reasonably possible. It doesn't give us indefinite time. It means that we must do everything in our power to get this done. But because of certain things, we don't have a specific 120 days to take a decision on this, Chairperson. So, Chair, I think what one can say about this court case is there was a huge attempt, or I would rather say a fundamental attempt by the judges to say we are not overstepping the separation of powers. Of course, there's a difference of opinion. The Chief Justice thinks this is a classic case of judicial overreach. And the majority then made a special effort through the judgment of Judge Froman to say, well, we're not overstepping. We're just saying to Parliament, you're expected to do something in terms of Section 89. You must do it. And that's a point that I think needs to be looked at as well, Chairperson. It says that when you have this evidence, when there is something going on, you must look at Section 89. You must implement it. We can't just sit and wait for it. So there's a kind of an obligation almost on Parliament to deal with Section 89. It doesn't come out clearly whether we must proceed or whether there's an obligation on a certain party or a member to then bring a motion, or whether we should even wait for a motion, or whether the House can move it without a motion. But I mean, I can't see how you can move it without a motion, but it says that you haven't done anything in terms of 89 and therefore you must do something. It's almost like what they said in Doctors for Life. If you do not get public participation going on a bill before you, you have to go out and solicit comments. You have to go find comments. You have to do whatever you can to get comments so that you have public participation. It's an obligation put on you. So that is something I think one must look at in the rules, because there might be a situation where there's a for lack of a better word, information in the media that points to a violation of the Constitution, but nobody moves that motion in the House. What should the House do in a situation like that? Chair, I can take questions on it, Chairperson, but I think in terms of what we need to do in this committee, giving effect to the judgment, is to look at those principles. I think the majority of them are captured in 232 of the Chief Justice's opinion, and draft something according to those lines, Chairperson. If you like, I can summarize it again, but I think I'm just going to repeat myself.
As we were trying to summarize a very detailed judgment. And that's fine, and thank you for that. And let us allow Honourable Steenhuisen to come in.
Thank you very much, Chairperson, and thanks, Mr. Jenkins, for the input there. Obviously, the case is, it's going to be a very difficult tightrope for us to walk to make sure that we're able to satisfy all the requirements. But to my mind, one of two of the key issues that I think we're going to have to grapple with as they relate to the judgment is around Section 89 itself and going back to what Section 89 says. And I think that one of the key elements that we're going to have to grapple with as a committee, because it's going to have a knock-on effect on whether a prima facie evidence exists, and that the rule as it's currently drafted for us talks a lot about prima facie case, and again to your point about who moves the motion and what triggers. So to me the first thing that we're going to have to grapple with is
a point of order. Sorry, Honourable Steenhuisen. I don't think we want to allow this. People must stay to the gallery there, take photos from there. Please, Honourable Dagan, you must protect us.
It's for my Farmers Weekly shoot.
Yeah, I think there's some things that must be clarified.
The Farmers Weekly have offered me the centerfold this week.
No.
We're here for rules, man. So, please.
So,
But of course, it's parliamentary staff who throw this thing.
Yep, then it should know. You can't.
Okay, no, we take the point. Let us move on.
thank you.
John, you wanted to conclude or not?
No, I'm busy working. I was just getting worked up. No, just to say that I think we're going to have to go back to Section 89, particularly if the rule's going to start dealing with prima facie, and determine and decide what is a serious violation of the Constitution. Because Section 89 uses the word serious violation of the Constitution or the law. How do we define a serious violation? And we're going to have to try and find some clarity around what is a serious violation. What Dr. Ndlozi may think is a serious violation, the Speaker of the National Assembly may not regard as a serious violation. So I think that's one of the first things we're going to have to grapple with. So before we even get into the rule and the prima facie, that's one thing we're going to have to deal with. The second dilemma that I think we have, and perhaps we could seek some guidance from you in this regard, is that I think there are two different scenarios. There's a scenario where a member of Parliament believes that the President has seriously violated the Constitution and tables a motion. And I think there's a process to follow, and we've dealt with that type of process going forward, and the Constitutional Court has said that the process is deficient. But what happens when the Constitutional Court rules that the President has violated the Constitution? And I'm unsure about what happens then, and the ability of Parliament to then set up a committee that would second guess or perhaps arrive at a different conclusion to a finding in the Concord of what they regard as a serious violation. And what would then be the trigger to put that before the House? Would that be a finding by the Constitutional Court automatically trigger a process in the National Assembly, or would the Speaker be obliged then to trigger that process in the National Assembly? But I think one of the dilemmas that we have is, how does a committee of Parliament take a Constitutional Court finding that the President has violated the Constitution and then adopt a committee process to embark upon audi ultram partem, which would have already taken place in a Concord process, and then arrives at a different conclusion to the Concord says, well, we disagree with the Concord that it was a a violation of the Constitution or serious violation of the Constitution. So to my mind, we're going to have to look at two different streams. One to deal with the tabling, the ordinary tabling of a motion in terms of Section 89, and a second stream to deal with a Concord finding that the President has. And I think that we're going to have different processes around it. So that's just my, I think that's a dilemma that I think we're going to have to grapple with before we even get into the functioning of the rule. Thank
No, thanks a lot, Chair. I think Honourable Steenhuisen has in part covered me on the issues of what constitutes a serious violation, because the term is debatable. And quite frankly, I think that lands us in some sort of a jiffy. And I think that needs clarity. I heard Advocate Jenkins, of course, they will come back to that particular aspect. Secondly, Chair, I think the biggest problem comes into how parliaments actually operate, because fundamentally a decision is taken on the basis of a vote. Now, how do you then create a new decision-making process? Because I'm looking at the scenario as an example of an ad hoc committee. Generally, the standing operating procedure of Parliament now is that an ad hoc committee will have 11 members, which 6 will come from the ANC, 2 from the DA, 1 from the EFF, and 2 of the other parties. Now, ordinarily, it becomes one of those 50+1 situations. Now, I'm not sure whether we can then subject a legal process to a vote, whereas the motion of no confidence does that. It's a political outlook, right? We're really not happy about how you're doing A, B, C, D. But Section 89 is looking at constitutional violations. And what's the deadlock breaking mechanism in that regard? Because if we are unable to clarify that, a parliamentary process in whatever way, which will do the fact-finding mission, we'll have to agree on some sort of report, and then that report then come to the House, which of course ordinarily then we have to vote, which is fine. But the spade work before that requires a deadlock breaking mechanism, and the parliamentary practice is a vote. So that subjects it by and large to a political intervention as opposed to a legal outlook of which is before us. It may well be a different case if, of course, like the Constitutional Court found that the President currently had breached, the Constitution. But even there, as Honourable Steenhuisen says, when you then establish an ad hoc committee which seeks to unravel a finding and seeks to arrive at a different conclusion, it becomes a total roundabout of madness. So I really, really hope that we can get that guidance, because I think it's at the heart of how any fact-finding mission would operate in terms of breaking a deadlock on what type of report would you submit. Because if you can't agree there, the House is going to act on the basis of what you present to them. And if it says, well, you know what, we've looked at this and we don't consider it to be serious, go jump, the House is left with no other conclusion other than to respond to what that fact-finding established committee or whatever, whether it's a standing committee or whatever you call it. Fundamentally, it's constrained by current norms that the only way to arrive at a decision is through a vote, because rarely we know that consensus becomes a norm on controversial issues in Parliament generally, whether it's this one or the next. Thanks, Chair.
Our honorables in the subcommittee. And then if we do that, I think members won't mind to do that. Mbuyiseni, won't mind that we do that. in the subcommittee general, we try to be as informal as possible. That we don't use honorable.
The problem is when we disagree, you're going to start reminding us that.
Honorable Meda.
Chairperson, I listened to what the colleagues say, and we shouldn't complicate things. There's a huge distinction between Section 102 and Section 89. As far as I'm concerned, Section 102 is a more political process, where the opposition party may have a problem with the president, and they want to score political points, and they come with a motion of no confidence. Section 89 is something completely different. That's why the test is also a much higher test. You need a 2/3 majority in the House. And Section 89 deals where you remove the president from office, and the Constitution clearly states there are 3 instances. It must be a serious violation of the Constitution. Even in the Nkandla judgment, when the court found that there was a violation of the Constitution, the court did not say it was a serious violation. The court could have said that. It didn't say that. When you deal with Section 89, it's almost a factual kind of situation where it should be so obvious that almost all the members, or 2/3, or even 100% should agree that this individual should be removed from office. For example, in subsection C, where the person cannot fulfill his office, the person suffered a stroke, for example. It's obvious the person should be removed. And the other 2 deals with serious misconduct or a serious violation. And then you should start looking at intent and those kind of things when you get to that position. But we shouldn't complicate it. There's a huge difference when we come to 89 compared to 102, which is basically, as far as I'm concerned, a more political process. This is a factual process. It shouldn't be that difficult.
Well, thank you very much, Chairperson. I think Honorable Steyn hasn't somehow covered me, because quite frankly, when you look at Section 89, it may not be easy to deal with one section of it or subsection of it. You can't deal with A and leave B and C. So, which means then, when we look into these matters, we'll have to deal with that section in total, A, B, and C. And also, I think the issue of the focus is very important, because we are dealing here with the matter of the court judgment. And that should be our focus. And then we create principles around that. What did the court say? You know, with regard to the majority judgment of the court. Now, that's where we should begin. I should therefore, I mean, Honorable Steyn is saying it's going to be a dual process. On one hand, we're going to look at the rules, at the same time we look at the court judgment. And of course, these can be looked into simultaneously. For instance, Chairperson, the majority judgment said a prerequisite for such removal was contingent on a factual inquiry into whether one of the 3 listed grounds in Section 89(1) was present, that is, serious violation of the Constitution or the law, serious misconduct, and inability to perform the functions of office. So I think we should put that in mind as we deal with these matters, and then we come to a conclusion of the court judgment. What is it that the court said the Parliament must do? It was held that the Assembly failed to put in place proper rules regulating a Section 891 procedure. It was also held that there was failure by the Assembly to properly determine whether the President had breached Section 891 of the Constitution, and that was a violation of et cetera, et cetera. So I think we've got to put our minds around that so that we be more focused on what we're trying to say. Thank you.
Thanks, Chair. Look, I think I appreciate this workshopping, and maybe we should be patient with each other to establish a common understanding of the judgment. We must not falter our interpretation. So we have to be very clear that we have appreciated fully what the judgment is. Now, the confusion, and I mean, this is a thing with judgments like this, is that They are serious judges or justices that give very powerful, counter arguments and so on and so forth. But the majority judgment holds the dictates. That's the first point of departure, the majority judgment. Yes, we can appreciate the counter-argument of the Chief Justice and its brilliance, but in relation to taking our key, how do we implement the majority judgment? And that's the first thing that's important here. And therefore, it seems to me that the bridge of the separation of powers comes precisely in a value judgment on the establishment of seriousness. So a court, if it is sensitive in my view, not to remove a president directly, it will not add the word serious violation. That is where it is giving us a bridge. What the inquiry therefore does, which I think the two examples that the Honorable Steenhuisen gives are very crucial. We're making rules for the future, but we have a delinquent as well in question who has been properly ruled to have violated the Constitution by the highest court in the land. But what didn't happen is that nobody has heard his side of the story. Nobody has heard his response, oral evidence, and it comes out in the judgment. We don't know, and if we are to establish seriousness, we need to all hear, did this guy have the intention to undermine the public protector's work in the investigation in Nkandla? Or as he said in his apology, he was just ill-advised or he did not understand the law. We have to be able to attach intention and say, no, you have intentionally undermined and therefore it's a serious violation. So we must establish that factually, that there is a serious violation. The second part is, what do the members of parliament vote on? So, and in my view, and you'll see why we think later on what we would propose is that that factual finding mission or factual finding process must be, as much as possible, conducted by legal experts, because it's a fact-finding mission. This happened, he has the right to present, to hear his side of the story, like in a company. The company, if the CEO has done something wrong, they get somebody from outside, some senior counsel, to do a report and recommend. So you could have been found guilty and there are sanctions to the guilt. Sanctions, the removal from office, or take your salary for 12 months and so on and so forth. But the board still needs to decide, because the CEO cannot be removed by somebody who is outside the company, who is not a member of the company. That's a fact-finding mission. And Section 89, according to the judgment, needs an inquiry before a debate can happen, which establishes for us the facts. Now, that, I think, the first two violations are different to the third. For an example, as the Honorable Mulder says, if a person is too old, and maybe he is not aware that he's old, he sleeps in parliament, he cannot lift up a pen, we must agree that this person must be removed from presidency. Or he's suffered a stroke, like one of the presidents of apartheid, and is still in denial that he cannot perform. Members of parliament must save the country because it's going to take dangerous decisions. Or there is a psychiatric report that this guy or this lady has gone mad, or has suffered some psychological, he can no longer be rational, and so on and so forth. That's why, on the last why, I think you can't take all the benefits because it's capacity, as it were. So that would be my interpretation, or it's not even an interpretation, it's very clear in the majority judgment. That's what we are called to do. Even if there would be a court judgment, I remember in the interrogation what the Chief Justice was struggling with is, he says, for instance, okay, if we find that the president has indeed committed murder, and then we do not take him to prison, don't you think that's a serious violation? I may think so, But Parliament must still go subject itself as long as you don't send him to prison. If you don't send him to prison, you are saying Parliament must go sit because you have said it's a sanction cause. For if you thought it was serious, why didn't you send him to prison? So for as long as they don't send the president to prison, we have to have our own satisfactory inquiry as a separate arm of the state. That is at least what my interpretation is. Thank you.
Chairperson, I indeed agree. I think the processes are two here. Because remember, we're a parliament, we're not a court of law, so this would still be largely political to a large extent, this process. It's the seriousness of the issue, because we are talking about a violation of the Constitution where we need to have a process that ensures that the president accounts fully to Parliament about his mistakes. I mean, for example, if you have a situation where the president has done something, you can't impose criminal penalties as Parliament, right? The courts of law would do that. But I think what Honorable Steenhuisen is saying, which we agree with fully, is that firstly there must be that political process internally in Parliament to say how do we table a motion in terms of Section 89 of the Constitution and have that and outline that parliamentary process. But at the same time to say that there might be instances or few incidents like where there was a constitutional court judgment. How do we also process that internally to arrive at a similar or more or less the same outcome? But I think I was chuckling here when I heard Honorable Ndlozi saying that we should invoke the idea alteram partem principle for the president so that he can come and explain his side of the story. And I agree with him fully. I wasn't chuckling because he made that point, but it reminded me of the SABC inquiry where we were saying exactly the same point about Claudi. I think it's important that we apply it across the board and consistently in future. So I think that's how we need to apply our minds to these things. I think these are impeachable offenses, even though they are highlighted in the Constitution. We can't expect the very same sections to explain serious violation to us. That is what this process must do. And while Advocate Jenkins was speaking at the beginning, right when he was providing his analysis, I thought it's one of the issues that he was going to touch on because he said he was going to return to it later. I don't know whether it's later today or at some other time in future. I don't know. Thank you, Chair.
Yes. Thank you, Chairperson. You see, in a democracy that is constitutionally based, I think we would have to continuously check and work within that constitutional arrangement. Yes, we have established the Constitutional Court, and at this moment we do give respect to what the Constitutional Court has said, and we will have to comply with that. But I think Hlengwa is raising a fundamental point, which is a little bit of a political problem, and also it relies on the votes. The issue of the proportionality. As a member of parliament, you get recognized inside the house. But the experience is, which is quite something that I want the legal person to talk, is that you are a member of an ANC or you are a member of NFP. What happens if the motion comes through you from the minority party? Quite clearly, the ANC might respond totally different. And then the political debate more than the detail of how that relationship is shaped. So it's important for this committee to look into that a little bit deeper, that at which stage and what capacity, because you can't just say as rules, we give you the authority to raise the motion. Whilst you know for a matter of fact that when you stand in the house, we look at your party credentials more than looking at the motion itself. And then the problem starts. You become more isolated and nobody comes to your rescue. And for me, that debate in the rules must be resolved. That how do we deal with that? We should not fudge it, because that's the realities that we are dealing with. If it deals with saying yes, the majority party is in existence, but what do you do with this particular motion, which is very crucial, because you must never be seen not to give respect to it, because if an individual has come to a conclusion that the president has not complied with the Constitution, what do we do? Because that right of that individual in the House becomes very much important. And the rules themselves must protect that particular individual and give him the power to be able to rise at that particular moment, and so that he can either take the process to the last with the speaker and in all the other ways, but it's all dependent on how do we design the rules themselves to protect minorities in the House itself. If you can't deal with that, because it's fundamentally touching on the voting patterns. So for me, that's the challenge that the rules must be able to deal with, that what do we do within that environment? And then the last one, Chairperson, or from what I hear, I think that's substantially that's what we want. That's why I'm saying that from ours, where we seated, as we would want to encourage, yes, the judgments are there, but in the near future, would it be necessary for the Constitutional Court to direct members of Parliament how to act? When we have established the rules, it means automatically the power of each individual in the House becomes very important, and it needs to be protected. That's the point. I'm just saying that, can we get more clarity about it, or can we get more guidance into it, that what must we do when the minorities or individuals in Parliament feel unprotected, you see, because you can't determine what is going to be the voting outcome, you see. And if the voting outcome says the ANC is in the minority, what do you do, you see? And the ANC thinks that the president is not conducting himself in terms of the Constitution. How do you protect that? Because that's the value of our Constitution, that we must protect each other. The majority can't be the total determinant of how the country comes to resolve a particular challenge. Because this has been the experience in the past, that if the majority party decides, then nobody knows what to do with this party, even if there's total dissatisfaction with the running of that particular office called the president. What do you think, Advocate Jenkins?
Honorable Mazoni wanted to make a point, but because we have been part of the team, may I just make a point? I just think that sometimes because of the current situation, we are really focusing on the current situation. We also ignore that we started reviewing the rules of National Assembly long before any judgment. Long before any judgment. Therefore, we must put ourselves, what would have said without all the judgment, to ensure that we give effect to Section 89 of our Constitution. And then, because if we don't do it that way, I think then we'll have a problem. And I think we must try our level best to do so, because we are setting the rules, formulating the rules, surely for future generations, for future parliaments, and because it seems now really we are almost like we are in impeachment. We are just regulating it and ensure that we give effect to 89 of the Section 89, the point as made by Honorable Melder. Let us do it that way. And then, because once we take ourselves to a current situation, surely we are not going to draft what we in fact would have drafted long time ago, before all the judgment were in fact were given on that, because we are working on it already. And then that's why then there are proposals that are put forward for your consideration. Maybe after Honorable Mazoni, we should allow then Honorable Jenkins again to make a general comment on some of the issues that are raised. And we go to proposal, because many of you already are touching on proposals. And then once we go to proposal, then we can then have a discussion on some of the issues on that. But my view is that let us take away that there's a current situation, that we are drafting this rule long before it. Of course, there's judgment that we respect, but we are drafting the rules not necessarily for the judgment only, because we already started drafting the rules. Let us then move in that understanding on that. Otherwise, again, we subject ourselves really on the issue that Honorable Melder was raising, the question of seriousness, and all the issue that was raised in there. I think that are very valid on that. Mazon, you want to take a platform?
Chair, thanks. Chair, I've been on the subcommittee since 2014, and in 2014 we first started debating how we would give effect to Rule 89. The problem is that we stopped debating it before we should have. We should have continued the debate, and that's why we faced with the problem that we faced with now. Chair, in 2014, this committee discussed certain issues which have now come up in this Concord judgment. So it's very difficult to separate ourselves as we talk now, because we do have this Concord judgment that I think we foresaw the inevitability of there being perhaps a Concord judgment that would essentially lead this committee as it has done so now. Now, in 2014, already the option of having an external panel was mooted. And at the time, we discussed as a committee that an external panel was certainly not the way to go, because the executive is held to account by Parliament. It is one of our roles. It is a constitutional obligation that we as members of Parliament have, is to hold the executive to account. So already when this was discussed in 2014, that was already something that was taken away. What was, however, identified as being a huge flaw was the fact that our ad hoc committee system, as the rules make provision for presently, had two fundamental flaws. The one is that it would not give effect to a constitutional court recommendation or requirement. So we had to come up with a committee that would give effect to the constitutional court requirement or mandate given to Parliament. And this is why we sit in the position we do now. We now have the Concord telling us you have to make a committee that gives effect to our recommendations and to our requirements. So that was the first conundrum, which we knew would come up. The second was the fact that Parliament in an ad hoc committee, or in a committee that would have to be established to give effect to 89, could not create law on the fly. That wasn't the role of this committee. The role of this committee would not be to create a law. It would be to give effect to a problem that existed within Parliament. So in other words, what we were looking at, and we looked extensively at things such as what happens in the United States of America, where they call a congressional hearing, for example. And their judicial commission then sits with a group of senators who act as a jury, and the president comes before them. An interesting fact is that over 60 possible impeachments have come before the American Senate since 1813, and only a third of them have actually ever seen it come to actual trial, with 2 American presidents being impeached in that period. So we can see that it's, even in very mature democracies that have gone through this process numerous times, there are challenges and impediments as they come along. And what we must realize with these rules, and that's why it's problematic that we didn't continue with the drafting of these rules as a subcommittee, is that these rules are not static. As we develop and as things occur, so we will have to change and adapt the rules to adapt to certain situations. And that's normal, because we're not drafting rules for the current government. We draft rules for any possible government that comes into Parliament, and we must always bear that in mind. But Chair, I think where we're deviating now, and where we possibly are straying, is as Honourable Steenhuisen and Honourable Kwankwa and Honourable Klenga and Honourable Boy and the doctor Dr. Ndlozi sitting opposite me have said, is that until we have a fundamental understanding of what would constitute a serious offence, we actually can't go further to discuss what kind of committee could look at that offence, because we first have to understand what the context of a serious breach is. And that was also viewed, and in 2014 we were saying at that time, how do we establish what a serious breach is? It's the same thing as gross abuse or gross misconduct. We have to, as a committee, accept that this is one of the very tough challenges that we face is to define what's serious breach, gross misconduct. We have to define these things in our rules. And we can't expect the National Assembly table to make these decisions on our behalf in the House, because we've already seen through various court actions what happens when we expect the NA table to take these decisions on our behalf. But Chair, fundamentally, one of the reasons that the very first rule that we changed as a subcommittee was we added the word, the Speaker of the House must act in an impartial fashion. Because if the Speaker of the House is not 100% impartial, you land up with a Mazibukova Speaker of Parliament scenario, where an opposition party, or even for that matter, someone from the governing party might feel that the Speaker has acted in a way that is not independent and fair to the House. So in all of this, we must remember fundamentally, we saw this problem coming, and that's why we said that the Speaker must act in a completely impartial manner. Because as Advocate Jenkins said, what happens in a case where it gets brought before the Speaker and the Speaker says, well, actually, I don't think this is a problem. And I loved what Honourable Klengwa said when he said, and then the committee's told to go and jump. Because let's be honest, that can happen if the Speaker is not completely 100% impartial. And Chair, my last comment on all of this is, when we draft these rules, part of what we draft must make sure that the rules of Parliament protect us from the majority of Parliament ever holding the power to disregard the opposition parties in any way, shape or form. That's why we have rules of Parliament. It's to protect from absolute power projecting onto Parliament absolutely. Thank you, Chair.
Then they must have something to drink. Advocate Kubisa will come in. Kubisa, want to come now?
Chairperson, just one thing. One point is that the point that is coming out, emerging from this, that when we draft the rules, we must also consider the fact that we draft them for posterity as well. That's one. Two, I would appreciate from now onwards that when we're giving a direction, that perhaps it be in a point form so that we're able to follow it coherently. Thank you, sir.
Thank you, Chairperson. No, I think the discussion so far was very valuable, and very valid points were made that we all can learn from. When Advocate Jenkins presented his input, he referred to a certain paragraph in the Constitutional Court judgment, and that spells out the mechanisms. And I think that is the first pillar that we need to focus on and to discuss. Secondly, our job as a subcommittee is to implement and give effect to the Constitutional Court judgment. That's the second principle. And this is what we're here for, and to reach consensus on this. The third one is what members has referred to. We are making decisions that will stand for many, many years to come, not only on the short term, but for the longer term as well, well past the 5th term of Parliament. So we have a draft rule dated from 2016, and I think the purpose of this committee is to refine that draft rule and to discuss the draft rule and to see how we can improve it. And lastly, then we must respect the parliamentary processes, from the subcommittee to the Rules Committee to the House, with consultations, so that we don't violate the parliamentary constitutional processes of this body. So I really support what you've said before you give to Advocate Jenkins, that we really take note of the discussion, but that we focus on what Honourable Glawley said. Let us focus on the principles, and let us see how do we move it forward to make a practical decision, recommendation to the Rules Committee. Thank you.
Yeah, thanks, Chair, and sorry to labour the point, but you know, and I've listened to what's been said, but why I raised the point about what constitutes serious up front is because it's going to bedevil the process the whole way through if we don't have some consensus around what is a serious conduct. And I say that because I heard what Dr. Ndlozi said around the committee determining the seriousness, and that's all well and good, and we can embark upon that process. But my concern is that, if one looks at the current rule before us, there's a process that has to take place before the motion even gets to the House. And that's that the Speaker has to satisfy herself, before it even appears in the order paper, that it meets the prescripts of Section 89. Now, I would regard a violation of the oath of office as a serious violation of the Constitution. A Speaker, I'm not saying this Speaker, I'm saying a Speaker, could say, oh, but that's just a mere formality that you have to forego before. That's not a serious violation. And so I think that's the point I tried to make, is that because what could happen is that a Speaker could gong the process out before it even passes the first hurdle, on the basis that, in her opinion, it's not a serious violation. And I think that's why I raised it up front. It's something we're going to have to grapple with, this issue of what is our common understanding as a subcommittee of the rules, or the Rules Committee and Parliament ultimately, of what is a serious violation. Otherwise, we're going to end up with skirmishes the whole way down the process, because what I regard as a serious violation of the Constitution could simply be dismissed as, it doesn't meet the prescripts of 89, therefore the motion can't even appear before the House. And then we'd have to find ourselves in court again, having to go and, asking the Constitutional Court once again to interpret what is a serious violation. So I think that's the context in which I raised it. I mean, I've no doubt that an ad hoc committee or the committee would be able to determine what is a serious violation. But my concern is that if we don't have a common understanding before the process even starts of what is a serious violation, then we're going to have to grapple with it at each phase. So it was in that context that I raised, and that's why I sought some guidance from Honourable Jenkins about whether there's any case law around what is a serious violation, what constitutes a definition of serious.
Thank you very much, Chairperson. I think to address the questions, I think there's a lot of similarities between the questions. And yes, I said I'll come back to the issue of seriousness without delay, and I'm going to come back to that now, and I'm kind of happy that I left it for members to give input before I put my head on the block for this matter. The issue of seriousness, whether it's defined or not, where does it fit in the process, is critical and it's crucial. It's the crux of the matter for me. I think if we deal with it in a process way of a member bringing the motion, or, as Honourable Steenhuisen said, what if the Concord makes a finding that there's been a violation of the Constitution and no member brings a motion? What is the responsibility of Parliament then to deal with that court case? As I said in my initial input, I think the court expects Parliament to do something even in that circumstance, to deal with that judgment, to say there's a judgment out there that says the President has breached the Constitution or a law, or is guilty of misconduct, or is incapable of performing the function, and then the Section 89 procedure must kick in. So we need to keep that in mind into initiating the process. Then when the process starts, the first point of call is, of course, the predetermination of whether one of those three grounds exists. And I think the focus is more on A and B rather than C. A and B being the misconduct, that's B. C being the violation of law or the Constitution, which must be serious. First of all, I would agree with Dr. Ndlozi that it would be overstepping the judicial function to actually make a finding to say this is serious and therefore Parliament must take notice. Section 89 says to determine whether it's serious and the court case together is a function of Parliament. It's not a function of the court. The court, in terms of section, I think it's 167, must make a finding whether there has been a breach of the Constitution. And if there's a breach, it must declare that action or law invalid. Well, not invalid, but to declare it unconstitutional, and then it can make a just and equitable order. So it won't be for a court to say it's serious. Now, I don't have to go into the minority-majority disagreement on this point of what is serious and whether we can determine it. The minority had a different view. The majority says you need to determine it. I think what the majority had in mind is to say, write it down so that we can have a process that is removed from the political agenda at that point. So what is serious? That's going to be a very difficult question. For me, there's two ways of which we can approach it. One is to say the certain action is serious. Honourable Steenhuisen mentioned a breach of the oath of office. Honourable Mulder said, look at intent, look at the reason why it's there. Is it gross negligence or intent? Usually that focuses on seriousness. But in law, and the judgment of Justice Zondo said, there's no definition for seriousness in law, so we can accept that. We're not going to have a definition. Parliament will have to determine its own definition. So I would, when I thought about this prior to hearing the inputs, but I'm glad that there's some agreement, at least on that point for me, I also thought of, what about gross negligence and intent? Regardless of what provision in the Constitution is being breached. That would constitute seriousness. Now, I think to make the debate around this a little bit easier, given the context of Parliament, which is made up of different political parties, I think it's very important to remember that the Constitutional Court clearly states that the fact-finding predetermination process, the sort of committee process to find out whether there's been a serious violation, is separate from actually debating the motion and voting on the motion. So even if we have a process, and I remember what or let me just remind myself as well, to make the debate around finding a definition for serious easier within the political context of Parliament, we must remember that whatever definition we give it, your political affiliation is going to be not exposed, is going to be lived out in the House, not in the committee. The committee is going to have a different process. And one needs to understand it to actually understand the court case, because the court case highlights the composition and the voting procedure within the committee as possible impediments for that process to get to the House. But the way Parliament operates is that we have to have proportional representation in committees. It must be in a manner consistent with democracy, and we must pass decisions in the committee in a manner consistent with democracy. So that is there. It's very difficult to get around it. But if we think that, okay, whatever fact-finding mission we do, we get to the House, at that point, even if there was a finding that said it was a serious misconduct or a serious violation, the House can still decide what they want to do with the President. That's because Section 89 says the President may be removed, not must be removed. So he may be removed. He or she may be removed. So, Chairperson, the issue of seriousness, I would suggest it's going to be easier to look at a definition when we're looking at intent, you know, what they call in law mens rea, but I mean, we've passed the Latin ages now, so is it intentional? Was there gross negligent part of that? And to get to that point, certainly we'll have to allow the President to give input into the process. Whether that's written or oral, I think that would be for the rules to determine or for the committee to decide, and that's something that we can keep in mind. That being said, when we get to the second stage of the process, just on the point of audi alteram partem, when we get to the second stage of the process, I would also suggest that when the House is going to take a decision to remove or not to remove the President should also be afforded an opportunity to say something in the House. It can't be just at the fact-finding process. And secondly, during the fact-finding process, one must also consider whether the President gets legal representation or is entitled to legal representation. Certainly there's been reference in the court case to that, and given the seriousness of losing your benefits, I would suggest that it should be seriously considered that should be allowed. It is more of a legal fact-finding process. Chairperson, I think the issue of protection of minorities, I haven't specifically referred to it, although I've touched on it, because I've just categorized all the questions in three areas. One is the seriousness, which I think I've dealt with. One is how do we bring that motion into the House or the issue into the House, even if no one moves a motion. And the last thing is the protection of minorities. I think this was said in the context of what I said before, of the report of the committee or the whole issue not being debated in the House. Section 42 is very clear that the National Assembly is there for public debate of national issues. So there must be a debate on this. It's not predetermined that because you have seriously violated the Constitution, you must be removed. I've said that already. But there must be a debate. So to deal with that, the rules must make it clear that whatever is said, or let's assume that there's going to be different views within a fact-finding mission or within the committee process, even at that stage. I'm saying that because I think most people will look with the eye onto the future. You do what you do today, you've got your eye on the future. So you know there's going to be a debate in the House. I'm not going to sit here in a committee and agree that there was a serious violation. I'm going to try and shield my president. Let's just take that for example. So let's assume that there will be different views within the committee. I think the rules must spell out, like with the case of legislation, that the committee can also then record minority views. Something in that line. But what it would be necessary is that you give that protection to minorities, as Honourable Zoni has said. I mean, the court expects that to happen. It cannot be that the minorities and their views are disregarded in this process. So, again, the rules there we have some examples in our rules of how to get a report with different views out there. I suggest we look at that again in the report. And then, obviously, the rules of debate needs to take that into consideration as well. Chairperson, let me leave it at that point for now. Thanks.
Thank you very much, Honourable Ndos.
Chair, two things quickly, which I think are very clear in the majority judgment. So I'm going to read it. What Justice Jafta does is to mention Section 89. And this is an important point we must be absolutely and crystally clear about. This provision empowers the Assembly, and the Assembly alone, to remove the President from office. He quotes Section 89, and he says, this provision empowers the Assembly, and the Assembly alone, to remove the President from office. The drafters of the Constitution were alive to the fact that the need to remove a sitting President from office may arise. Hence, this section allocates that power to the Assembly, presumably because it's the Assembly that elects the President. It is only fitting that the same body should have the power to remove the person elected from office. Then he says, the impeachment process, for the impeachment process to commence, the Assembly must have determined that one of the listed grounds exists. This is so because grounds constitute conditions for the President's removal. A removal of the President where none of these grounds established would not be a removal contemplated in this section. Equally, a process for removal of the President where none of those grounds exist would amount to a process not authorized by the section. I will jump, so I'm reading from 173 of the judgment downward. These are important pages to establish where the power lies. So I want to answer some questions which we must be brave to admit. We must not think we can if the, okay, I'll get back to that just now. So another important line perhaps to state here is that since the power to remove is institutional, the Assembly must decide and facilitate the initiation of the preliminary stage. It may very well be that each member of the Assembly has the right to initiate the process. So that has to do with the process. I want to speak to this question of seriousness because it's addressed as well here. In their words, in the words of the majority judgment. 170. Yes, 77. Okay, let's start 76. The power to remove the President from office is available to the Assembly only if one of the listed grounds available. I've already read that. It is evident that the drafters left the details relating to the grounds to the Assembly to spell out, but the drafters could have not contemplated that members of the Assembly would individually have to determine what constitutes a serious violation of the law or the constitutional conduct on the part of the President, which in the first place amounts to misconduct, and whether in the second place such conduct may be characterized as serious misconduct. If this were to be the opposition, then we would end up with divergent views on what is serious violation of the Constitution or the law and what amounts to serious misconduct envisaged in this section. And since the determination of these grounds falls within the exclusive jurisdiction of the Assembly, it and it alone is entitled to determine them. This means that there must be an institutional predetermination of what a serious violation of the Constitution or the law is. The same must apply to serious misconduct and inability to perform functions of the office. Let's leave the speaker. Once more, it is left to the Assembly to determine circumstances under which the President removed from office on one of these grounds may forbid benefits. And then finally, honorable members, for the impeachment process to commence, the Assembly must determine that one of the listed grounds is established or exists. Now, so we have no option but to have our process. Even if there might be someone else out there who has a process, we are suspended. That we have to take the responsibility to have our own process. And according to this interpretation of the Constitution, or at least according to Section 89, whether we are second-guessing someone or not is no longer relevant. We must have our process. So you may as well say there's a court ruling. On the basis of the court ruling only, you can't remove the president on the basis of Section 89. You may on the basis of the motion of no confidence, but not on the basis of Section 89. So if there's a serious violation by the Constitution and we evoke Section 89, the Parliament is obliged to put that into a process. And part of the evidence that will be presented is precisely the court judgment. That here is the judgment, the president can also lead his legal evidence, and so on and so forth. So I wanted to clear that. The second point I want to clear is this minority what. In this institutional predetermination, is not majorities and minorities and what. The judgment is clear. One, it says on 194, JAFTA is dealing with this question of the ad hoc committee, including committees of parliament. In fact, if you read these sections from 194, 95, 96, he's outlawing. He says the committee process is not what is contemplated. The ad hoc committee process is not what is contemplated, and he gives reasons why. Because you can't arrive at facts by voting. You can arrive at what must be the punishment by voting. But the determination of facts doesn't need. We can't all of us agree by a majority that this is blue when it is red. Then we are not fit to be in this house, basically. Facts must be established. So Parliament must have its process. That's our first responsibility, is to establish how that process is going to be, and it cannot be on the basis of the committees that exist in our rules, including the ad hoc committee. Now, the reason why I was disagreeing, and I thought Advocate Jafta will correct this, when he was reading the summary, Jenkins, sorry, Jafta is the justice. What he read as the principles is the summary of the Chief Justice in a minority judgment. He is summarizing what he thinks are the principles on the basis of what Justice Jafta's judgment says. No, that's not what we need. We can. That's what we have a space here to say what must be, and this is why there is no compromise or there is no textbook violation of separation of powers. What he's doing there by interpreting it that way is that he's trying to ground a wrong interpretation of the majority judgment. The majority judgment is not prescribing. It doesn't have prescriptions of this is how the rule, what the rule must say, and it must follow. So we may as well come back to the initial conversation of having, that's why I was making an example about companies. But if you think companies are minority, as minority bodies in the society, the Judicial Service Commission, how does it impeach judges? And that could be the framework which we use. South Africa has already answered the question of impeachment. It's just it did in a different regime of the state. So we could look at the Judicial Service Commission Act and how judges are impeached. But the perfect example is precisely what we've been recommending when we were starting, that because he's the president, even here they say he's no longer a member of the House, he only lives by the rules when he's in the House. He's in the different arm of the state. Let's get retired judges that will establish for us the facts, bring the report to Parliament, and then we vote or we debate. But on the basis, firstly, that there must be a predetermination. That predetermination doesn't have to be by members of Parliament themselves. And those examples are there in other countries, in the report of other countries that we looked at. I'm just saying we have that option. It has not been taken from us. It has, if it was taken from us, it would have been a textbook case of judicial overreach. But the judges didn't do that. So we still have that option. Finally, Chairperson, I want to appreciate that there is obviously, and this is the practicality of people who have been in Parliament for a while, there's how do you process the motion? I think that's where the Speaker doesn't have to decide if it's serious or not. So nobody must decide a priori, because that's what the process must determine. So if you are a member, an ordinary member, and you believe that there must be an impeachment, you draft a motion that there must be an impeachment, that there must be a process of impeachment, and you tell the Speaker that there is 1 and 2 and 3. The Speaker then subjects the process to the House. The House votes, and we're not voting on a new committee or what. It must not be decided on an ad hoc basis. Then the people who process that, call the president and do all of that important work of establishing the facts, must always, in my view, be there and be determined at the beginning of every parliament. The 5th Democratic Parliament, the 6th Democratic, like that. And it could be 4 or 5 judges, depending on which one will be available, we get that one to do the process of impeachment. And then I agree, the president must have legal representation. The president must, and that body must have the powers of subpoena. If it doesn't have the powers of subpoena, it won't be effective. But the president must have legal representation. There must be an evidence leader or indictment and all those things. It must be a proper trial. And in my view, that's what that section, that's the best way to do it without compromising majorities and what Honorable Nyami Boy was saying. If I'm chairing that committee, a sitting president who is most likely, as the judgment says, who is most likely to be the party leader of the majority party in the House, may not feel that they must answer to, particularly on things that are going to impact on their removal. So to give them a fair trial, we just step aside and watch. But it is one that is owned by ourselves, is commissioned by our resolutions, and reports to us. And we take the final decision of whether we remove him or her. Thank you.
Now, colleagues, can we take a 15-minute break? John, do you want to speak now after break, please?
Let me just a quick
point.
Break. Yeah, I think that Mr. Mpofu better watch out when Dr. Ndlozi starts with his LLD next. But I mean, I think that for me, and the point I've been raising since the beginning is captured succinctly in 178. It talks about institutional predetermination. And that, to my mind, is a direction to us that we're going to have to grapple with the definition of serious violation. And that would solve the problem then of removing the power of the Speaker to decide whether it's a serious violation or not. So I think that that direction to us, and that's why I made the point originally, is that before we even start the process, we've got to have an institutional predetermination of what is serious violation. And until we grapple with that, we're not going to be able to get through the rest. So, because that's going to be the first hurdle for a motion to be deemed competent to appear before the House. Section 89 motion. I think we will get into the nuts and bolts around external committee versus internal committee, and I think there's some legal advice we're going to have to get around Parliament's role in terms of the Constitution and its responsibilities and duties, and where the President could argue that, well, it's not Parliament holding him accountable, it's an external body, and is that a valid process? But I mean, we'll get into the nuts and bolts here, but to my mind, the first thing we've got to grapple with is that institutional predetermination of what is a serious violation or serious misconduct.
Take a 15-minute break, colleagues. With that seriousness. It's a very serious break, this one. Honorable Mpofu. Honorable members, let's resume. Let us start with our meeting. It's a subcommittee of the Rules Committee. We don't take a final decision. We make recommendation to the mother body that then makes recommendation to the National Assembly. I'm not sure whether we still want to discuss seriousness and seriousness and seriousness and seriousness. And I think what we should do now is to allow the Secretary to the National Assembly to present what we are proposing, Natasha, what we propose in 2016. Then members then will comment on what we have proposed, look at it. It may also cover the question of a panel of experts, all the issues that are there. And then after that, we have a discussion. Let us then start with that. And Natasha wanted to make a point before allowing. Okay.
Chair, just a quick point, because I think it's important when, and I agree with you 100%, now that we've looked at issues, then the Secretariat needs to go and put together exactly what is defined by seriousness and the nature of seriousness. But Advocate Jenkins said something which concerned me, which he reiterated a few times, and I wish he was in here to hear me, but he's not. But it's all right, because my colleagues are here, and they're the people that need to hear this. Advocate Jenkins referred to gross negligence on many occasions. Now, one thing that I noted from the judgment is that the majority judgment was very careful in the fact that it never mentioned the word negligent. In fact, the judges went so far as to say inability to perform function or inability to perform duty, but they did not use the word negligent. And that is because negligence cannot be a defense. It can't be a defense. So while our Secretariat goes and looks at how we define seriousness, we cannot say that if a president is negligent, it then absolves him from a serious misconduct or a serious contravention of the Constitution, because it's like a lifeguard saying, well, there was a pretty girl on the beach, so I turned to talk to her, and while I was talking to her, someone drowned, and I was negligent in my duty. That's not a defense. So the president can't then say, I was negligent in my duty as president, and therefore I rely on that as my defense. So when we draft these things, Chair, the Secretariat's going to have to be very careful and look at the nuances, especially of the judgment, because I think it's very telling that the word negligent is never used in that judgment. It's phrased in many ways, except using the word actually negligent. Chair, then also, when the Secretariat does it, Chair, 178 of the judgment, I cannot reiterate its importance. And it starts 178, and since the determination of these matters falls within the exclusive jurisdiction of the Assembly, it and it alone is entitled to determine them. Now, that to me is it's the alpha and omega of how we take this issue forward. It is completely up to us and determined by us. So, Chair, I think we need to look at that very seriously. Chair, also, I heard someone mention, and I can't remember who it was, that we must avoid ever a frivolous motion or a frivolous attempt at impeachment. I think the fact that to bring this motion in the first place, it would have to be a substantive motion, would stop the frivolity. There we go. How's that for a tongue twister to start the year off? Ever coming, because, you know, what you don't want is it to become a political basketball that gets played with. Impeachment is not a play tool. Impeachment is a very serious issue, and it must be viewed as such. Chair, and then also, when one looks at the word debate in the House, I think the Secretariat must also be very careful in the way we word this, because it was something that was brought up in 2014. There is a difference between how we debate something in a committee and how we debate something in the House. And even in a motion of no confidence, when it's debated in the House, the person against whom the motion is aimed does not have the right of reply in the House during the debate. They would have the right of reply if it was debated in an ad hoc committee or in a portfolio committee. That would be the opportunity for the right of reply to be heard. So we must just also look at the rules, because we might, I mean, if we as a committee decide that in an impeachment debate in the House, the President would be allowed to answer, if that's what we decide upon, we would have to perhaps then look at the way we change the debate in the House, because there is a clear differentiation between committee debate and parliamentary debate.
Honorable Mbuyise.
Yes, you know, the way you are guiding us, Honorable Mdagani, I even wondered why they didn't put you in the NEC, because you are very powerful. I mean, guiding such an important process, I don't know what happens to talent in that house, but it's okay. You know, here we are. I think that we must not overlook this disagreement, because it must be clear. We couldn't go to the rules to define seriousness. We couldn't do that. That's what must be determined by a process if the grounds for the violation of Section 89 are there. So let's read this thing again, and I want to say some shocking, maybe it's not shocking after all, but for an example, the Constitution says in Section 89, the Assembly by a resolution adopted with a supporting vote of at least 2/3 of its members may remove the President from office only on the grounds of a serious violation of the Constitution or the law, serious misconduct, inability to perform. So there might be a finding that there was a serious violation. The Constitution says we may, it doesn't say we must. And that's an important reading. So an impeachment finding will say, because serious violation will include value judgments. Actually, a large part of it will include value judgment. It cannot be put in definitions of rules. And you must not be scared that we get a process that says President X has seriously violated the Constitution or the law, or is guilty of misconduct. And members of Parliament come and they don't remove them, because the Constitution says they may. So what is missing there, which is implicit there, is that they may not. They may not. So it's not they must remove. If that was the case, you know, anybody, when a court of law, for an example, says, you know, this guy is guilty of serious misconduct, it will be automatic. But it's may. And that's why Justice Jafta says this provision empowers the assembly and the assembly alone to remove the president. It's constellating on that probability. They may remove the president so we are not tasking, or we couldn't task the secretary to go and predetermine in a form of definitions what serious misconduct, what serious violation is. No, every impeachment process must determine on the basis of the given circumstances, which may not be predetermined, which cannot be predetermined, in fact, whether the person is, has seriously violated the Constitution or not. I just wanted to underscore that because I think there is a slight diversion in relation to that, because I keep emphasizing that, we're not to define. We put a process to constantly tell us on basis of circumstances if there are grounds for serious violation. Then we go to the House. So people who are reasonable or who are unreasonable after a credible process has said a person seriously violated the Constitution, they may still keep them there. The Constitution, unfortunately, allows it. And so I think that clarification is important. So maybe we must clarify that before we go to the proposal. Chairperson, thank you.
Okay. I think Honorable Mbuyiseni, I think we are comfortable with that one. I think it's very helpful for us to do so, because the reason why I say set up a process is a process that is going to determine whether it's a serious or not a serious thing. Based on that, then the report to the chamber. The chamber discuss. In fact, the process can say serious violation. The chamber says you are mad. There's nothing serious here. They can do so, because the chamber only that will take that decision at the end, whether you impeach or not impeach. But I think what we should do, colleagues, is to allow. Hlengwa, you wanted to make a point? No. Let us allow then the Secretary of the National Assembly look at it and see what you want to do. Take the platform, Masbu.
Thank you, Chair, and good afternoon, honorable members. I am now presenting on the document titled Additional Rules, Removal from Office of President. Chair will start from part 3 of that document. I'm sure members have read the document, so I will not go through it word for word, but I'll highlight issues that I believe this structure needs to take care of.
Now, Masbu, yeah? I would be happy if you go detailed to it.
Okay, no, it's fine.
Because it's guiding us again on many issues that we have already broadly debated. It just will be very important for us to take your time a little bit.
That's fine. I'll do so, Chair. Obviously, the rule numbers will be updated because the rules have since been amended. Now, the first part, which in terms of the document is 102B1, says that the motion to remove president must be based on a recommendation to that effect by a committee of the House appointed for that purpose. The issue of the ad hoc committee has been discussed, and the court has also expressed itself on the issue of ad hoc committee. At the time, the view was that the ad hoc committee would be the best mechanism in this regard, but clearly we need to consider the nature of the committee that must be established that will take care of this. Of course, the one option is to have a committee, a permanent structure, which would be composed as and when a matter arises. So you could have a committee with some form of terms of reference. A member may by a motion propose that the Assembly initiates the process for impeachment of the President. There's been a discussion as to whether it will always be incumbent on members to propose, to initiate this process, or the Assembly could on its own initiate the process. I think this committee must express itself on that. Then 102C states the criteria which the motion to initiate must comply with. Now, the first one, A, deals with the role of the Speaker. Now, the court judgment has said something about a motion of this nature should not be based on the generosity of the Speaker, whether it is allowed or disallowed, which seems to suggest that the role of the Speaker at that point should be limited. So the committee would need to deal with the issue of the criteria. Criteria B or A deals with prima facie evidence that would warrant consideration by the House. B, the motion must propose that the specified charge be referred to a committee of the House. The charge must be confined to a charge contemplated in Section 89, and also the charge should concern the charge must relate to an action conducted by the President in person, not to his general functions. That's what was proposed here. And that the motion must be consistent with the Constitution, the law, the rules, and may not contain statements that are not necessary to make it intelligible. So the point that I would like to make here, honorable members, is we have to grapple with the vetting process. So when a member tables the motion, who vets the motion to ensure that it complies with these rules? It would ordinarily have been the Speaker. We must talk about that. Or should it be the structure that will have been established to process impeachment motions that does the vetting of the motion? Non-compliance with criteria, the Speaker may disallow proposed motion, and if she or he disallows the motion, the member concerned must be informed. The member can amend the motion and resubmit it. If again the motion or is not amended, still does not comply, the member must be informed of the reasons for disallowing it, and also the House must be informed as to why the motion was disallowed. We then come to also a critical step in the process, the programming for consideration by the House. Now, ordinarily, at this stage, this is where a motion is either given the green light or is killed, for lack of a better word, or disagreed, or whatever, voted down by the House. Now, the question is, for this type of motion, is there room for that? Is there room for the House to block, I think that's the appropriate word, to block the motion from even getting into a process within the system? And my reading of the judgment is that that is not desirable, because in that manner you have a hurdle in the process which would effectively kill the motion, and the motion would not even be processed by a structure. So we must deal with that. Of course, you have options. One of the options would still be to go through this process, but the House would be aware that it cannot block such motions. And another process would be, once a motion of that nature is submitted, it does not go via the House, it goes directly to the committee, which must do the vetting of the motion. So that's one option. Here it said that it must be programmed on the next sitting day of the House, and if the House is not sitting for a period of more than 14 days, the Speaker may appoint an ad hoc committee. Of course, we're talking ad hoc committee at the time. So if we do not have an ad hoc committee, it will be completely different process that will be followed. Again, the scope of debate. The scope of debate on the motion must be confined to the proposed referral of the charge to a committee and related matters, and may not extend to the charge itself. The idea being that the committee must still grapple with these issues, with the charge, and therefore the debate itself must not get into those details. 102G, invitation to President to respond. So what was envisaged here was that at the point that the House says yes, there must be a committee established, and this motion must be referred to that committee. The President is informed immediately that the committee has been established, and the details of the charge, and invite him or her to respond within 14 days. You then had the terms of reference. Unless the House determines otherwise, the terms of reference of the committee to which the charge is referred to inquire into and pronounce upon the charge. If the charge is sustained as being beyond reasonable doubt, to determine its seriousness, if applicable, and to table a report. So in the proposal, it was to be the committee itself that determines the seriousness of the charge. And also there was an option given that instead of saying beyond reasonable doubt, you could say on a balance of probabilities as the test to be applied there. 102I, the committee may exercise all the powers provided for, it's now Rule 167, for purposes of carrying out its mandate. It must comply with the rules. The committee must conduct its inquiry in accordance with a procedure that is reasonable and procedurally fair. The president has the right to be heard in his or her own defense and to be assisted by a legal practitioner or other experts. The committee may appoint one or more legal practitioners or other experts to assist it in an advisory capacity. Now, members will be aware that the judgment says there must be a preliminary process before you delve into the detail of the process. So what if that preliminary process is conducted by this committee? You could have a situation where the committee deals with the initial part, whether it consults experts, whatever form of experts you have, and then the committee submits a preliminary report to the House to say there are grounds for proceeding with impeachment, or we do not believe that there are grounds for proceeding with impeachment. So that's how you could formulate the preliminary process. Then consideration of the report. When the report is tabled, it must be programmed for debate and decision in the House without delay. And of course, this is at the end of the process. The committee comes back with a report, and if the committee recommends in its report that the president be removed from office, the question must be voted on in the House, and if it is supported by at least 2/3 of the members of the House, the president is thereby duly removed from office with immediate effect. What the rules did not deal with is the mode of voting in the House. And it's another issue that arose with the motion of no confidence, and it's a matter that the committee might want to consider, the mode of voting with regard to this motion. Mr. Ngwangwa, I'm still presenting. Removal of president from office in the case of inability to perform the functions of the office. For purposes of proceedings of the president to remove the president from office in the case of president's inability to perform the functions of the office, the term charge in the rules must be understood as the grounds for averring the president's inability to perform the functions of office. If in relation to a charge in terms of Section 89, the president is unable to comply fully with these rules in person, the committee may, in a preliminary report to the House, recommend that another person be authorized to act for the president in these proceedings. Honorable members, the issue of panel was discussed by the committee, and a legal opinion to that effect was also obtained. What the legal opinion effectively said was that, look, these processes must be led by members of parliament. However, you could have a panel whose terms of reference would still need to be defined, which would act in an advisory capacity to a committee of parliament. So that matter was discussed at that point when the committee dealt with these proposals. So, Chair, these are the proposals that were developed at the time. Obviously, they have to be updated to be in line with the judgment. I have sought to give certain options. So, in summary, there's a motion by a member. The committee must decide what happens to that motion. The motion must comply, obviously, with certain guidelines. Does it go directly to the House? And I'm putting a question mark there. Does it go to the House for the House to vote on the motion? And when it votes on the motion, it can say yes or no. So we must be aware of that. Or you have a motion which would then be directed to a structure established to consider Section 89 issues. And that structure does the assessment, the vetting of the motion. And the structure says, we think this is a frivolous motion, therefore we should do nothing with it. Or we think, okay, it's not frivolous, but it does not sufficiently contain the basis for impeachment. Or we think there is sufficient basis for impeachment, and therefore the impeachment process must be embarked on. And of course, the nature of that committee, because remember there's the issue of proportionality, you need to discuss that. Does it consult experts at that point before it comes to the preliminary report to the House, and before you embark on the full impeachment process? So once the committee says, let's say the committee says, yes, go ahead, and there's agreement that you go ahead, you then get into the detail of the impeachment, where you have hearings and whatever else you want to have in that process. So that's how I see the process, Chair. And at the end, it comes to the House. The 2/3 applies at that point. When the committee has concluded its processes, reports to the House, then that's where you then have the 2/3. If 2/3 says yes, then the motion is carried. Chair, thank you so much.
Well, thank you very much, Masubu, for the presentation. Let us invite members to comment on the presentation. Honorable Carter.
Thank you, Chair, and thank you for the presentation. Chair, I think just one important thing that I don't, that I would have liked to see here is if we go to the Mogoeng judgment of the 22nd of June, which was specifically on secret ballot issues, I think this would be a matter that should be a secret ballot issue. And therefore, also of what Honourable Boy was saying earlier on, that it will protect members of Parliament who has taken an oath of office but has to toe party lines. And not only specifically for this, but I think that although we are here specifically for the Section 89, we should look at Section 102 as well, to bring the secret ballot, which is the same way that the person was elected into the position, that they must be removed out of a position by secret ballot. So I think it's just important that we incorporate that. As Schedule 3 prescribes the election by secret ballot, rules must then deal with a removal. And it's also protecting the Speaker and protecting all other members. From our side, that would be it for now. Thank you.
Thank you very much, Honourable Boy.
So, I think we must deal with the debate of when you are a victim.
When what?
The victimhood. The fact that the Member of Parliament raises the issue, and part of this document doesn't protect that member. It could be a point of concern because the President, you give him so many times. You give him legal experts and everything. But the drafter of the motion, you don't say anything much. But we have got so huge expectation from that member to be able to construct. So I'm just saying that a member himself, when he starts that process, can Parliament come to his side and assist him to be able to draft this motion and do his thing very properly, so that it doesn't get shut down by the Speaker on the basis that you couldn't write it properly, you see, or you couldn't explain what you wanted. So that initial stage, it's important that the dissatisfaction of the member is being brought through in a more proper, organized way, the capability and the capacity of that particular member. So that's my one part. You see, in what Mazoni has been saying, we've been grappling with the power of the Speaker. Look, we can't say that it's impartiality, but given the nature and the seriousness of this matter, why would it be solely the Speaker to make that type of decision? Because if you have got dissatisfaction with the Speaker, nowhere does it say take it to the Rules Committee, so that the Rules Committee can become the arbiter, rather than having the Speaker being the sole person who can then make the decision. It's not about the current individuals or whatsoever, but it's the principle of saying, can anyone, even in future, be sure, given the proportionality, that the Speaker can be so powerful in the party, and then they can go against you, you can't do anything. She's a powerful, or he is a powerful person. So for me, it would be important to bring in the Rules Committee to assist that particular, so that Parliament, through its own structures, is able to give that power, rather than giving it only to the Speaker. Because also the other challenge I have with the Speaker solo is because when there's a dispute, who comes in? Does that decision still lie with the Speaker to say, I was correct, you were wrong? It's a problem. We should always make sure, and I know that we've always been saying that we must protect members of Parliament as much as we can. So in the Rules Committee, it's easy for that particular member to put the suggestion forward that this is what I've attempted, and it seems as if the Speaker has not been able to go along with the decision or with my suggestion. And the Rules Committee becomes the final arbiter in the relation to what happens to that particular member. So if you could, within this process, emphasize that, it would be quite comfortable to make sure that members of Parliament feel protected, so that if you don't have the capacity, you are a one-man party, and you have this allegation, it's quite clear that those that are in, because in our process now we have developed some coalitions have been beginning to take place. So they should be able to sponsor it to help raise the matter within the Rules Committee, and the Rules Committee takes it up to its finality. Let the arbiter not be only be the Speaker herself, or himself, because it can become a little bit problematic. My last point, Chairperson, it is also in this thing of seriousness. There's no, if you put it against the Bill of Rights, there's no, if I was in America in the Bill Clinton situation, simple, straightforward. For me, the violation of human rights, gender insensitivity, if you subtopic those issues, I mean, if in the Nkandla matter, you simply say that when the president starts delving into the fiscus, which is not what he's supposed to be doing, then it becomes a serious offense, you see, because he can't say, I didn't know that people are building a house all around me, you see. A president can't, I mean, nobody can say that doesn't. So for me, the subtopicing of seriousness could be the matter that we could present here. So that people become conscious that if ever I get to a presidency, it's very clear that I must not be seen putting my fingers, because as a finance minister, why do you want to get involved? There's a rape charge made by a public person to say that the president wanted to rape me. Why do you want to have a long process? It's a straight charge, so that you should be conscious that never rape when you're a president. Don't indulge in those type of things. Be a figure that society can look up to. But if you don't take that presidency serious yourself, that's where the violation of the Constitution comes in. And these things must be directed on the basis of how you conduct yourself, than be generous and what. The seriousness must be about that. Don't do things that will demean the office itself. Because if you demean the offices of the presidency, you create a problem even for parliamentarians of how they're beginning to engage with you within the public space.
Yeah. So the issue here that I think we must do it much quicker, in my view, is to go back to our principles and realize that we need a new attempt. Firstly, we couldn't subject the motion for impeachment to a vote. The judgment outrules that, or to a committee that arrives at decisions through consensus. So maybe, and that's why I think there's a big room here. We should open our minds to be creative. There's no prescription. What the judgment does is to kill the options that we have, including the option of a motion that must be voted on in order for a process to happen. It says that's not what this Section 89 contemplates. Because if we can vote that no, there must not be an impeachment process, then we are no longer within the regime of Section 89. So we ought to say, what kind of a process allows the impeachment to happen? That is, for it to be referred, for the impeachment process to happen without it being blocked by the politics of majoritarianism. So that's the first sort of challenge. The second challenge is, so I would say that that's the first thing that we must answer in terms of process. What kind of an initiation of a motion allows us to have that motion implemented without it being subjected to a majoritarian politics? That's the first principle. The second one is that what kind of a process do we subject the president to in which it establishes facts that also is not about majoritarianism? So really, it seems to me that the answer to the first question is, when the person gives rights to the speaker, and I'm fine with the speaker, they must give evidence, a prima facie evidence, that I think there must be a process to impeach the president. And the speaker can say, okay, you have not drafted it well, this is how it can be drafted. Refers it to this body that we must answer to the second question. And our proposal is that it must be retired independent judges. We must have a process of establishing them when the parliament term begins. 5 of them, and then 3 of them may sit in that to consider those specific cases of Section 89. So between themselves and the speaker, I think we have a leeway to determine without, because what we need to determine, what we need to clear out in the beginning is that such a decision is not about majoritarianism. Because if that's the case, we can just block even before the process begins. So those are the 2 challenges that we have. And then the other challenge, that, where is this document? Yes. You see, okay, so that has to do with with Section 81, Section 89, subsection 1A and B only. So we still need a process for the last one, which is if the guy is suffered from a stroke. And I think that we need a set of, we still need a predetermining process even in that case, but it can't be the same way as it has to be different. So those are the 3 challenges I put to us. And I argue we must go answer those 3 questions. We'll have a new draft, completely new. Because this one, its philosophy has been rendered futile by the judgment. It has been rendered impotent it is unable to produce effect to Section 89 because it depends on committees, it depends on the ad hoc committee, which have been outruled by the Court of Law. Now, this leaves me with the last challenge. President might say when he appears in front of those judges, this is not Parliament. No, he can't. Because it would have been a decision of Parliament to establish such a committee. It will have delegated fact-finding, and it's there in the examples were provided. It would have been us who have taken the decision in our rules that, and you know, those judges may never work for 20 years. We put them there on standby, it's like a funeral committee. If nobody dies, the funeral committee never comes to effect. So somebody must die for the funeral committee to come. But either way, we can't decide the funeral committee upon death. The wisdom is to do it before. In this case, it's even more wise to establish that committee before you do the misconduct, because you can't say those judges are biased. Because they were put on standby before you engaged in serious violation of the Constitution, in serious misconduct, and so on and so forth. I argue that that's our best mechanism. But those are my proposals. Finally, two pieces of legislation. One is the Judicial Service Commission Act. It has a process of impeaching judges. The second one is the Powers and Privileges Committee Act that impeaches us, like that deals with our misconduct. Principles are already very clear there. If we could go into it, we can. But I think that we say these are the three questions you must answer and use to arrive at a rule, at a draft rule. Look at the Judicial Service Commission Act, look at the Powers and Privileges Act. And then we'll have a completely different thing. But in relation to what's happening there at the end, except the committees and all of that, the thinking was actually spot on to separate between A and B and C, because they require a different form of judgment. But that's our take. I have to emphasize that the judgment gives us that space. If we read it closely, it gives us that space to even use judges, because if they are decided by us, nobody can say, no, this is not Parliament holding me. No, we are giving you a fair trial before we remove you or we keep you. We are deciding, we want to give you, in fact, we are so good that we give you a fair trial. You appear in front of people who are not politically conflicted. And who else in society has better passed that test, even better than priests, are judges. Retired judges who don't need a promotion, who don't need to be a chief justice, Hashem. They just want society. They are concerned about the future. So that is important. That's why, I mean, when you select commissions, we see there the wisdom. Are you going to go for a sitting judge? Are you going to go for a retired judge? It strengthens your capacity for the credibility of the process, even if we may have all the complete trust on judges. But some of these judges, what I like, part of what they do, you should see the Africans' judgment that was read before us. One of the judges confesses, puts their own, that I too went to an Afrikaans dominated language school, blah, 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 and blah, blah. They demonstrate to you that they too are human. But the highest test is a retired judge, chief. It doesn't need to be a chief justice tomorrow or to be given anything. They are now concerned about society. And that's a fair trial. We give you a tribunal. They give us an answer that you have violated the Constitution seriously. Then we go to the House. And then you can decide you may remove the president or not. There we can do the politics. But the first process, what is envisaged that it must be politics-free. And those are the three important tests that it must pass. Thank you very much.
I just want to clarify, Dr. Ndlozi. So the proposal is that there will be this independent panel, say retired judges, and there will be no committee of Parliament. Is that your proposal?
Yes, absolutely. Any committee is outruled. Because how committees, this is a legal fact-finding process. What do you need a committee for? It's not an ad hoc committee. Actually, the judgment criticizes the ad hoc committee. You must see, because that's what you guys submitted there to the constitutional. You submitted probably this document, I don't know. But I can hear it thinking, was part of the discussion of the judgment that no, an ad hoc committee can't do that, as well as an ordinary committee. So the majority judgment outrules both. But for an example, we've just allowed former President Kgalema Motlanthe to do something about apartheid laws. And nobody can say, no, that's not parliament. But he's not a member of parliament. We have got options. That's why the majority judgment is actually very strong. It doesn't tell us prescriptively what to do. So we have just to pass the test of its principles, and which are constitutional rather than anything else outside of the Constitution. They are constitutional. What does Section 89 envisage? And I argue that it doesn't envisage any committee before, because any committee is going to decide by majority all those things which is already crafted within the current rules. So that we can call it a panel, a impeachment panel. And it must be 5 retired judges who must specifically say those things. If any one of them passes away, we replace. But they must be, their term is 5 years, and one of them must be a chair. One of them must be a chair. That's our concrete proposal. And that's the best mechanism in my view, which will give us the best. So the prior process is when I draft, the speaker, I agree, in fact, we agree, that the speaker should be given, because she acts on behalf of the assembly. She must be given the power. For if she decides irrationally, we can always go to court and say, but it's irrational, we've given evidence. She can say, no, it's not properly crafted. Because she's supported, and this is the Honorable Nyami's point, she acts on our behalf. If I come to her and say, I've got evidence, I believe that Section 89 must be evoked, and then I've written that down with the supporting evidence, so I've put it, she says, no, it's not properly drafted, I'm going to redraft it for you, and then I'm going to refer it to the panel of impeachment. The panel of impeachment does its job, it comes back to us, we debate. We may remove the president or we may not. That's really my point. So finally, just the final part, the rest of the other principles are proper. Legal representation on behalf of the president, the subpoena powers, and so on and so forth must be given to this panel of impeachment, which must have a chairperson and must constitute 5 judges. Thank you very much. 3 of which can sit.
Okay, thank you very much. Let me take Honorable Hlengwa. Yeah, noted.
No, thanks, Chair. I just want to process what has been said. So I'm just saying, like a ambulance, fresh logo. But I think, Chair, we're making progress in answering. No, let me just say this one point, Chair. I think we are making progress in answering the question I raised of a deadlock breaking mechanism. So I think that's important. I think what arises now, of course, is the process in which, should we go down the route of the judges, the process of appointing those judges, which is obviously something we need to consider. Because what must not end up arising is a situation where Parliament is seen to be deferring its duties and responsibilities of accountability elsewhere. So there must be a situation wherein Parliament's role in that regard is emphasized. Because whilst Dr. Ndlozi says we are nice people and we are giving you a fair trial, fundamentally the people who have been given the duty and responsibility to oversee the President and the Executive is Parliament. And that is very, very important and must be duly, considered in that regard. But in the main, I think that this sort of gives us a direction which can be taken. But Chairperson, the flip side of that coin, which I think we must consider very seriously, is the resistance of Parliament itself, which has probably landed us in this crisis, of holding the President to account, whether it's the current or past. Because if we are seriously saying that a question and answer session once per quarter is holding the President accountable, I think that doesn't make sense in any form or way. Secondly, if we think that we are passing presidency vote one budgets without any form of scrutiny, then you are setting up a presidency in itself for failure. Because I believe that in between they called it the impeachment panel, or they say impeachment committee, or whichever one. In between the impeachment panel and the parliamentary process, there still needs to be a parliamentary mechanism of oversight over the presidency, which must enable and assist that impeachment panel. It cannot be that all government departments have got a portfolio committee and the president accounts nowhere to Parliament. Because then in that way we have totally given up, said, right, you know what, the accountability of the president for all intents and purposes does not reside with us. So we need to build in parliamentary capacity in that regard, Chairperson, to give expression to whatever an impeachment panel will be. There needs to be a parliamentary sounding board in that regard. And it cannot be the Speaker alone, who may be conflicted in certain instances or not. Whether you say it's the presiding officers, whether it's the Speaker, Deputy Speaker, and the three other presiding officers, whatever. But we need to build in a mechanism as well, which ensures that the impeachment panel is not reliant on an individual in the person of the Speaker, but is reliant on a transparent process. So I'm building into what Dr. Ndlozi is saying. But fundamentally, the duty of oversight and accountability resides with Parliament. We may, because if even that report of the impeachment panel comes to Parliament, if it only comes to the Speaker, we must be able to build any process on how that report is received. I mean, I know one person at some point said the former public protector was very strategic in bringing the report to Parliament when she said put it under lock and key because her term was ending and all sorts of other things. And said the Speaker may have had a discretion to say, well, I'll keep it under lock and key until whatever. So we must not build an over-reliance, Chairperson, in an individual. For argument's sake, let's assume that the Speaker is conflicted in this impeachment process you want to. With Nae, he or she played some manga business, which gives rise to the president being impeached, or a process being set into motion. So I'm saying, Chair, let us maybe in the drafting consider building in a parliamentary mechanism. I'm just not clear what it is now because as I said, it's a legal puzzle. But I believe we need to create a system of checks and balance in order for Parliament itself to say we are accountable and own. If I'm a panel of judges now ends the mess up, we need to be able to have a corrective action of some sort or the other. So initially, Chair, just maybe in response to that, I'll come back with the other things that I wanted to say. But I think in clearing the deadlock breaking mechanism, let us build on what has been said and put it to some test or other. But I think what Dr. Ndlozi has said lays a foundation, which how can we move forward? We must find the middle way in this regard. But we are compromised by the fact that majoritarianism may, overtake a legitimate legal process. So if anybody wants to play the whole majoritarian what, let them take it to a motion of no confidence and not compromise the legal outlook which is envisaged in Section 89. Thanks, Chair.
Thank you, Chair. I think there's been some very interesting matters raised. I think if one looks at 175 to 179, it appears that the judge himself envisages a three-stage process. He envisages a preliminary process, he envisages an impeachment process, and then he envisages the third and final culmination, which would be a vote in the House. So you could well end up with an anomaly where somebody could be impeached by the committee, but not removed as a member or not removed as the president, because that's what it comes down to as the vote, the third and final stage, which would be unusual, but certainly I think that's also why it's covered under the May. And I think that envisagement is set out by the judge at 181, where he says not only at the preliminary stage, but also at the stage of actual impeachment, up to what he says is the final stage of voting on whether the president should be removed from office. So there exists a possibility that this committee, whether it's an external or internal panel, could impeach the president, but the House votes not to remove him from office. The second thing I think we just need to get clarity on is the power of the National Assembly to delegate its responsibility, because the Constitution at 89 puts this ball firmly in the National Assembly's orbit. And I just think that we need to perhaps get some legal opinion and legal advice around the implications, because the power for a committee of Parliament to do its work is vested in 56 of the Constitution. And that gives Parliament evidence information, which would, gives parliamentary committees the powers to summon, to produce documents, etc. And it says the National Assembly. And if one looks at 46, the definitions of the National Assembly are set out there, and it refers to 350, no more than X number of men and women elected, and it sets out the criteria of what is the National Assembly. So I think that the legal clarity that I think that I would like to seek and see is whether in fact the Parliament is able to delegate that function to members or not members of the Parliament as defined in 46, and what powers that committee would then have, because they wouldn't have the constitutional power to do that, because the members of that would not be members of the National Assembly, and what the effect of a finding of theirs would be, being that they sort of are operating in this grey area, neither fish nor fowl, neither judiciary nor member of Parliament, what their powers and ability and the force of their recommendations would be. We deal with recommendations from portfolio committees, we deal with recommendations from Chapter 9 institutions, and these are all recommendations that are set up to us. So I think that 57 does, however, give us the opportunity to make our own rules and regulations controlling its internal arrangements, proceedings and procedures. But I think that the comfort I'm looking for is a legal opinion that says that if we were to delegate that authority to an external body or external panel, whether they would have the same force and effect and what powers they would have, would they be regarded as a committee of the National Assembly, as in terms of the strict definition set out at 46. And then again, I just think that if we, and sorry to harp on about it, I think that we remove the discretion of the Speaker, the malevolent discretion of the Speaker, if we have that predetermined set of criteria that JAFTA refers to at 178. Because then, if the Speaker refuses it, it then becomes an irrational and unreasonable decision by virtue of the fact that, well, Parliament's already decided these are the list, and you could always put a clause at the end which says, and any other transgression that the National Assembly may, by resolution, regard as being a serious violation. So you could have if you have an unforeseen circumstance, have that. But I think that what it does then is it creates certainty. It reduces the ability for malevolent interpretation of serious, and allows us then to be able to exercise our rights as members of Parliament to be able to table motions in terms of Section 89 without an unfair or unnecessary impediments being put in the way for us to do that. That's just some of the discussion I think we need to get clarity on as we move forward.
I know that Advocate Jenkins also is here. From time to time, you will also come in to assist. We've been discussing some of the issues. Dr. Ndlozi and John, I think we can also work on this issue yourself, how you want to propose. It's just you are the one who are drafting the rules. then we must draft the rules accordingly. And then if we can't make point, we can make 3 options. I think we are free to do so, just to ensure that at least we have applied our mind as broad as possible. We can also use Dr. Ndlozi, the panel of judges to be assisting members, a committee of members. You can also do that. I'm just saying there are a lot of combinations that we have to work it out, just to ensure that the point that John is raising is an important point, because if it says it's only the National Assembly, only and only National Assembly, it means all of us as members of National Assembly. And but Jenkins will come in. Let's take Honorable Kubisa.
Oh.
You will come all over. Yeah.
Thank you very much, Chairperson. No, I'm glad honorable members have hinged on a point that I was thinking of whilst Dr. Ndlozi was still putting forth his views. And of course, he came out with some interesting points around the issue of the question of a majority scoopering the minority. And also the issue of that legal panel. He also brought in the issue of the high-level panel, which is led by the former President Motlanthe. What was ringing in my mind was the question of where Parliament lies in and how to match the two, what us was bringing in, and with what we're bringing in at the moment, because it would be important to make this process a fair trial. A fair trial would mean getting an independent body. But the question that remains is the duty and the obligation of Parliament as espoused in the Constitution. So that element must also be brought in. Where do we bring in Parliament to do its oversight? I think these two processes are matchable. They could be matched. The issue of the panel, because we have got a precedent, how it was, that panel came in, that was led by Honorable Motlanthe, and it brought a report to Parliament, and that report was discussed. And then, but Parliament must not be seen to be abdicating its responsibility of oversight. I think that is the crux of the matter. That as Parliament, we still must play a role. We must be able to process all these issues, because at the end of the day, the buck stops with Parliament. So, to me, that is the crux of the matter as well. How we do that, we need to be assisted by the legal fundis to ensure that Parliament, within the rules, is well represented, to ensure that it plays its role, so that it cannot be seen to be abdicating its responsibility. How Parliament delegates that responsibility as well must be well enunciated within the ambit of the rules and procedures that govern how Parliament functions. That's my take, Chairperson.
Chairperson, thank you very much. My reading of the judgment and understanding of certain aspects of it is that indeed it does say that the current configuration of the portfolio committee system in terms of the current dispensation of the rules is inadequate in terms of dealing with Section 89 of the Constitution. But it doesn't say that Parliament can therefore not relook into that system and establish a committee or a system that would speak to Section 89 of the Constitution, right? It means when you use the portfolio committee or the ad hoc system, you can't really give effect to Section 89. But it doesn't take away our mandate and constitutional duty to say we can establish another form of a committee system that would look into Section 89. But where we differ maybe slightly with Honorable Ndlozi and the EFF is that we agree entirely that it's what we've also been saying on the sidelines, that what should happen is that the person then who should chair that session should be a retired judge. but there must be participation, or members of parliament should form part and parcel of that political process, because it's an impeachment is a political process when you do it in parliament, right? It's still a largely political process because the president accounts to us. But the other issue, Chairperson, where we sit, I think the Constitutional Court judges were saying, in essence, put in simple English or in layman terms, that the president must get an opportunity to account for whatever allegations of misconduct or violation of the Constitution that were leveling against him before the matter is debated and decided upon in Parliament. Which means we can't have a system that turns the situation upside down, where motions do not even get to Parliament. But then the role of the Speaker, from where I'm sitting, and insofar as we're concerned, should be that you write directly to the Speaker, like we normally do, and the Speaker then would have to refer the matter to the committee that we've established, right? And have no power to say yes or no, right? But remember, the Speaker, as the head of the institution, would have to then put in motion all the processes that you need to establish such a committee and provide it with all the necessary resources, because you can't bypass the Speaker, who then controls the very same resources. Even from a political perspective, it would not make sense. So as to say the Speaker can't say yes or no, but she's the first point of call, then you'd have whatever portfolio committee or other processes we've set in motion, which would then be kicked in by the Speaker's correspondent saying, I've received this, act on it. But our view is that members of Parliament should form part and parcel of that committee chaired by a retired judge. Thank you ever so much, Chairperson.
Thank you, Chairperson. It's good to have faith in judges. I served 3 years on the Judicial Services Commission, and trust me, they're only human as well. Retired judges also. There are certain things that Parliament cannot shy away from, and one of them is our responsibility in terms of Section 89 of the Constitution. It's one thing to get expertise from whoever to assist, but Parliament will have to take its own responsibility in terms of that. My first take on the proposal of having this external panel, I'm a bit skeptical because I do not want to see that the powers of Parliament or the legislative arm should be undermined in any way whatsoever. And I know there is the danger of majoritarianism and et cetera, but once again I say, when it comes to Section 89, it cannot and should not be about playing politics. It should be quite clear what the situation is. On a lighter note, can you imagine when it comes to the election of a president, that we get 5 retired judges to make a recommendation as to who would be the best president? It's unthinkable.
Melda, I thought that you were assisting us, Melda. What is your proposal? Yeah, I think the point that you are raising is that a committee of whatever you call it, but that should involve members of Parliament.
Absolutely.
Whatever you call it, impeachment committee, whatever committee that you call.
Parliament cannot
outsource it.
Outsource our responsibility.
Yeah. Okay. At least I'm clear.
Thank you, Chairperson. Just to link up with the point that Honourable Dr. Dlozi made, in this document that was presented by Mr. Kasu, in the first paragraph, it does not exclude the possibility that a committee appointed by the House may employ the services and the assistance of legal experts. So that is a possibility that we can incorporate that idea raised by Dr. Dlozi, that the committee may ask for the assistance of legal experts in the committee. That's the first point. Secondly, the document that was presented to us now is dated April 2016. The court judgment that we've received is dated 29 December 2017. I think it'll help us in the subcommittee if we can get an updated draft rule based on the judgment of the Constitutional Court, so that we can have an updated, so we can make sure that the draft rule that the subcommittee considers is updated and based on the Constitutional Court judgment, so that there is no gaps, no ambiguity, and that we have the same document, look at it, discuss it, amend it, and then we can go to various political parties to say, okay, this is a draft recommendation. Before we go to the rules, how do we handle it? I make a proposal in that regard. Thank you.
No, I just thought that you will also take a point that no other person is going to draft it except you. You are drafters, yourself. And then there's no other team somewhere that is going to assist us. It is you who have to draft these rules. And therefore, as you speak, also assist us to shape it in a manner that assists us. We don't have another team somewhere that is waiting to draft it. It's you who are drafting it. The team that we are having in Parliament is to assist us to put it together. But it is you who have to draft it. And then we must be clear about what you are proposing and then how we want to move forward. And then we can then take it forward and that. Honorable Paul?
I do think that we should concede that the point we want to make around committees, the judgment was against Parliament on this particular one. In fact, if you go to 180 of the judgment, you go to 181, you go to 182, what the judges are saying that base your analysis or your work on how serious you treat that 89-1. They say unless and until Parliament realizes that 89-1 is where the crucial part is, so that the relevance of what Dr. Ndlozi is raising becomes the area of focus, because it then means that at the initial stage, you have given the power to some people to be able to assist you to arrive at a decision of how that process is to begin to unfold. I'll take you to, in the judgment, Chair, so that I don't take, because you will have to go through 184, which I've just read now. Now, in 196, in the result, I conclude that Section 891 implicitly imposes an obligation on the Assembly to make rules specifically tailored for an impeachment process contemplated in that section. As a whole, that the Assembly has, in breach of Section 891 of the Constitution, failed to make rules regulating the impeachment process envisaged in that section. So that's how far it is. It can be. Now, you see, if you go through from 182 onward, I'll even show you that whatever we're concerned about is a little bit of a problem. The initiation of such proceeding is inherently partisan, as the aim from the outset is the removal of the president. Now, this is what is presented by the Deputy Speaker in the Assembly as part of our motivation. And this is where the Constitutional Court rejects our proposal, that those ad hoc committees, by parity of reasoning, the committee system is not suitable here too. The ad hoc committee do not constitute a mechanism contemplated in Section 891. For all the reasons set out in the judgment, and even going into detail dealing with the Mazibuko case. So we are in a very slippery road against the judgment if you want to recreate or try to sustain the argument that Honorable Sostian has been trying to say is within the Constitution. It seems as if the judgment in itself has already gone through that route after the presentation by the Deputy Speaker, which is, it means, because he was trying to defend our committee systems. He was trying to defend our committee systems and everything. But if you go through from 180 to 195, you find quite extensively why judges feel that our committee system is at a weaker level to deal with impeachment. So 89.1, they direct us to read that 89.1 and base the impeachment argument or the creation of a committee on the seriousness that the Constitution is providing.
Honorable Boy, I think we are assisting us, but also we must provide what we do then. Because the point that is raised there, that the current mechanism cannot assist us to deal with Section 89(1). But it doesn't say, therefore, we can't create anything in Parliament to address that. It says that the portfolio committees, the stand ad hoc committee issue cannot assist us there. But I think the court didn't say that what structure then we should set up. They're leaving to us. We have to demonstrate to them that the structure that we are creating can deal with Section 89(1) for the purposes of regulating the impeachment of the area. I think it's helpful, but let us also go to what exactly now.
You see, Chairperson, we must read the judgment and listen to the motivation of the judges, so that when we start working on contextualization, what I'm trying to advance for within this context is the logic that Dr. Ndlovu has offered, that use the panel of experts to become part of your creation and mitigating between the power of the speaker and also the power of the individual, which is where I'm trying to say, it seems there's some logic, and it seems the judgment in itself can look more better than only relying on an ad hoc committee, that panel, which is a new innovative thinking from his part, that can we consider it quite extensively and a little bit more serious, because as you read the judgment, it seems as if in the nature that we have proposed in that draft document, the courts have already applied their minds and they've already rejected it. So I'm just saying, build the capability around accepting what Dr. Ndlovu is offering, and we build that capacity. But the judgment, if you go on, even as it deals with remedy, it does raise the questions of even of the power is to grant a just and equitable order. And the judges then show from their own position of being in the Constitutional Court, what does it imply? And they then say it's upon Parliament to accept the fact that those small coordinating committees doesn't assist, and they don't get to deter them as judges to be able to advance a constitutional. They didn't want to put it straightforward, that they would want to make sure that that constitution, the way we have seen it from the parliamentary point of view, our committee system is not going to help with an impeachment. And that's why I'm saying that I would want us to seriously consider the proposal that has been forwarded by Dr. Ndlovu.
Thank you, Chairperson.
Sorry, Doctor. If you go to 216 in the judgment, it says, in any event, the proposed order doesn't usurp the Assembly's power. It merely directs that the Assembly must exercise its power without delay. That's what the judgment says in 216. So it talks to the reality of how we've been running our own system, and it tries to improve after it could see, after the Deputy Speaker put up a lot of argument, which the court didn't agree with.
No, thank you, Chairperson. I'd just like to put something for the committee out there. I think the crux of it, and I can elaborate a little bit on it a bit more, is that whatever stage in the process we are at, if you look at paragraph 179, it's the Assembly that bears the exclusive power, and it's the Assembly that will have to take a decision. So in paragraph 179, it says, the Assembly must have determined that one of the listed grounds exists. So the court says you can have let's deal only with the majority judgment. It says that you must have a mechanism, committee or mechanism. Now, the present system of committees and ad hoc committees, court found is insufficient for the purpose of Section 89, specifically narrow scope of 89. But whatever we decide in this committee, whatever recommendation is made to the Rules Committee to say, let's have an external panel, or let's have a committee chaired by a retired judge, or a committee chaired by a member of parliament, but then advised by certain legal people, it will still be a report that must go to the House, and that's my reading. I might be mistaken, but the reading I have is that the House will take a decision after, well, not after, but it's included in the preliminary stage. The House must take a decision that one of those grounds exists in Section 189, Section 89(1) A, B, and C. And thereafter, they will take a vote. Now, that for me is a very critical area, because if the House takes a decision there that none of the grounds exist, of course, you can't move to the second stage. You can't then move to a debate on whether to sit. But it's, I think that is something that will have to be dealt with. But of course, the House can be challenged on that. I mean, if the evidence is clear that it is a serious violation of the Constitution, you have to go to the second phase. And if I may, Chairperson, I think that is why the majority judgment also said, contrary to the minority judgment, that you have to define serious. We want to see what you consider serious, so that we know how you're going to deal with this matter. In other words, it's not going to be an arbitrary matter, it's going to be rule-based. The whole thing is going to be rule-based. And that's different to what the minority said. The minority said seriousness is a value judgment. So it can go this way, it can go that way. And the majority said, no, we want you to tell us what is serious for you as Parliament. Write it down so that we don't have a problem with dealing. I see I've got some disagreement here, but if I can then just like emphasize the point I'm trying to make is, put in your rules what is serious, deal with it, and take a decision whether that conduct that we have now discussed in the fact-finding preliminary matter constitute that, and from there you go to the second process, which is then voting. Even if it is serious, you can still vote to say that the President should not be removed. Thank you, Chair.
Yeah. The challenge, I think, given to us at the core is when Parliament establishes a panel of judges, and that's the central question. Is it abdicating its responsibility to hold the President accountable? And I argue not, precisely because of these stages that Justice Jafta is determining. Firstly, it would have been our decision. So when you establish a commission of inquiry, the judge in the commission of inquiry is not acting on behalf of the judiciary. And they may actually be a sitting judge. They're not acting on behalf of the judiciary. They are not there in their capacity as the judiciary. They're acting on behalf of the President. Their administrative duties. You've got a Davis Tax Commission, for an example, which is a panel of experts. You've got people who remove us there in Parliament. They are not you. You've got a set of people there who are professional hooligans you have approved in these rules. They are not you, but they remove us. They've removed me many times from the House, but they are not members of Parliament. The dead lady, what do we call her? The one who carries the Sergeant at Arms is not a member of Parliament, but she acts, she has powers in the rules. They are delegated through decisions. So don't be scared. That panel of experts is not removing the President. No, it's not. It is expertise that we are looking for, number one. Number two, we are giving the highest test, because what is outruled here is in the wisdom of, it's not the mechanism per se of our committees, is that at the initial stage, really, you can't subject this to a decision of politicians. These are facts. These are facts. These are not, let's vote. So it must be impartial. It must, you understand? It's an impeachment process. In fact, he says somewhere, he uses the word a trial, but he says it can be an investigation. When that person of the investigator in the ad hoc committees, what do you call her? The one who cross-examines. Yeah, that guy. You are not disputing to that. Now, President Zuma has just elected a commission of inquiry into state capture. He did not say, no, it's not you, doing it. Because at some point, you need experts, particularly on this important thing of removing a person because of misconduct. Give them a fair trial. What is the highest test of this fair trial in relation to Parliament? For them to come, present and defend themselves and so on and so forth, we hear, we look at it, then the report comes to you. Because the Constitution says you may or you may not. That power lies in the National Assembly. It doesn't lie in the panel of experts, which we propose must be retired judges. And the reason why is particularly for this principle, which is implicit in the judgment, in the criticism of our committees. It's our involvement. Because we, at the end, are the ones that are removing. It says that where Honorable Nyami Boyi reads, particularly because we are removing in the end. So we say, no problem, we have a chance to go there to people who are not removing you, but we have delegated the power to listen to you. Factually, you defending yourself and all of that, the report comes. It's fair. Companies do it every day. How can we as an important institution be scared of what companies are doing every day and we always accept? The other day people were saying multi-choice must do an independent investigation, or those people of international bodies, multinational companies. How more credible are we? If we are to be convinced, it's if the investigation is conducted by an independent body. Then they have exposed themselves. The test, that's the highest test. If it's internal, it's subject to our own political, because at the end we remove. That power is not moved. That's why he gives us stages. That's the first point I wanted to make. I think the advocate is wrong. The advocate must distinguish between when the judge is dealing with an argument and unpacking an argument and the conclusions of those arguments in the judgment. And at all times, the majority judgment takes precedence, is what we have to comply with. That's why myself, I keep reading the majority judgment, because the majority judgment it encapsulates everybody and it's law. That's the law that we must follow. Committees are not going to be good. Ad hoc committees, page 82, section 1, okay, 187 up to 196 deals with the question of ad hoc committees. Then after that, they deal with the question of the failure to hold the president accountable from 197. Now, the last thing I want to deal with, Honorable Chairperson, is we're trying to implement Section 89. We're not, there are other many ways of holding the president accountable. What we are seized with is the expression of 89. There's still question and answer session. There's still ad hoc committees. There's still motion of no confidence. Those are all, that's why JAFTA says we would be wrong to say that there was no attempt to hold the president accountable. Therefore, the question is it in relation to Section 89? It says you have failed in relation to Section 89. Because that's what the EFF was there about, you see. Is that, no, this guy must be impeached. A disciplinary with the UDM as well as COPE. So my point really here is don't digress. The president can still be, interrogated in many and different ways, actually directly by members of parliament. But, and these are really my last words, Section 89 envisages a predetermined process of investigations, objectively. What is the highest test of that? It's independent, retired panel of judges that gives us our report, and then we attack. Whatever president, after an independent process, comes and still wants to stay, obviously will be a very pompous president. But MPs are subjective. MPs are subjective. We, members of the ruling party in the panel, for an example, have all types of fears. That president that they'll be interrogating could visit them in the NEC or in the Central Command team. So that is really at the level of an objective process determining an investigation. So that is what we have to say. Yeah. Even us MPs who are in the opposition who are subjective, we always don't like the ruling party's president. Anyway, these days they put up very difficult ones to agree with. That's really the test here, Honorable Chairperson. I think Honorable Nyami Boyi has saved much of the sections I wanted to read. We are outlawed from doing the ordinary thing, really.
No, certainly. I think I understand entirely the rationale behind the points that were made by Honorable Ndlozi. In fact, if you look at where we are, we're not too far apart, because we're saying merge the two systems, allow politicians to play a part in it, because it's a political process in our view. An impeachment is a political process. That the judges, obviously, as we're saying, retired judges would still play a part. We said, for example, you'd have one chairing, or you can even have one or two or three as part and parcel of that exercise. But the report that would then go to Parliament for processing cannot be one that is put together by politicians. But politicians should be able to interrogate the president, ask him questions, because when you talk about misconduct, there are a lot of gray areas. Maybe Section 81A of the Constitution, say 89 rather, if you look at A there, it talks about violation of the Constitution. I think that would be easier to determine when it comes to having judges dealing with that process. But when you talk about misconduct, it would include a number of things, unless we bed down rather the grounds of misconduct, and we are clear about that. So we're not too far apart and so far. But all we are saying is that political parties should still be allowed to play a process in that. I accept what Honorable Nyambi Boyi said insofar as how the judges have reflected on the issues of our committee system. I agree. But we must bear in mind that they were dealing with the current system once again. And if they were to tell us what to do and how to manage or determine and control our internal arrangements, then they'd be violating Section 57 of the Constitution. It means that we can still decide on the best mechanism going forward on how best to deal with this matter. But our view is that we should not exclude political parties from playing an integral part in that process and ask political questions. A large part of the questions that would ask when it comes to misconduct would be based on value judgments, as Honorable Ndlozi has said. And value judgments would be influenced largely by our political ideologies. But when it comes to constitutional violations, for example, I think the issues would be more clear-cut.
I think, thank you, sir.
Colleagues, what I wanted to make a proposal. We have heard this, I think we have exhausted it. We are allowed to give options. We are not trying to convince each other until the end. We can give options. We are going to draft 2 or 3 options. One is a panel of judges. One is a combination of the 2 members and the legal aspect. We put it there, have discussion in our parties. We come back here, we see then whether we are able to persuade each other or not on that. I think we should do it that way. Otherwise, again, we can repeat ourselves forever on this issue. I think we have made the point. We have exhausted the issue. I think we are very clear now with the point that is being made on this matter. And then Dr. Melda also took the point, and then Ndlozi, very persuasive. Okay.
Sorry, Chairperson, I'm sorry. I had forgotten that in our model, the political parties can have legal representatives who or not, but they can have legal representatives. Our point is that stage one really must be constituted in the highest legal test for free and fair trial. So you can send legal representatives to the panel, they can be allowed to present evidence, they can be allowed to interrogate, and so on and so forth. I forgot that part in our panel of judges, which is really the first stage, before it comes to the House for debate, which is the second stage. Then the last stage is voting. Yes.
Chair, I just want to say that the one option that we might present is a committee that is constituted like this committee, because this committee is not constituted proportionally. So you do not have the question of one party having 6 members and another 3 members. You have this committee in that fashion. You also have the disciplinary committee in that fashion, not like portfolio committees. So that is one option that you could consider.
No, I was going to say, let me make the point earlier. Besides the judgment, this is now the state law advisor, Chair. In conclusion, they say in 34, however, in our view, there's nothing preventing the NA from providing the rules that the resolution or decision by the Speaker establishment of an ad hoc committee may permit to employ the assistance of experts, such as legal experts, in the discharge of their duties. This is what the state law advises us to be able to do, both in 34 and 35.
But bearing in mind, that was done before the judgment.
I'm saying, Chairperson, you see, Chair, also try to listen to yourself. You are saying we should make suggestions based on the documentation in front of us. If you could please give me that liberatory role that I express myself as a member of parliament. It's very much important. So even if it was before or not, but the crucial part that I'm trying to remotivate and put is the need for legal experts at the preliminary stage of the process itself. That's the principle we should be able to agree on. And from there on, we will then continue looking at how do you constitute a committee that could assist that preliminary stage. If we are in agreement, Chair, it's what I think would be in the best interest, because that's what the judgment is concerned about throughout, that the preliminary stage is very vital to fairness in justice.
No, Honorable Boyd, the point that I'm raising, bearing in mind that we are the one who are drafting this. Drafting this, we have already covered the external legal aspect. You can call them judges, you can call senior counsel, you can call them whatever you call, but you may need them in stage one, because stage one is very important for you to have an idea. And then from that idea, then you go for your house. You debate it. And then if you debate it, then is another issue how you do that. Of course, when you debate things anyway in the chamber, you need majority. And then majority may decide the way it is, and the whole thing can. But it's important, the first stage, the point that you are raising is here. In fact, we are arguing very strong here. It is put here precise because the point that you raised earlier on, that the first stage is the most important stage. It will go to clarify you seriousness, violation, what is meant by that, and then take it to the next second stage, third stage, and then we are going on that. I think the point that we were making, even prior to the meeting today, I think it is here already on that issue. And I think that you will make proposals, you will make 2 options. One option is the one that you are talking about, a combination of members plus the legal aspect. Another one, of course, also members, general members, in a manner that is no proportional representation, is just a team and working there to assist us on that. But even that team will need legal support I think the team is raised on that. I think when that one is fine. I think also we do accept that the motion, Honorable Laws, I think we do accept that the motion will be submitted to the Speaker. The motion is subjected to the Speaker based on what the criteria. We look at it, says it's fine, take it to the committee work on it and come to the chamber, have a discussion, debate it, and then we move forward on that issue. Advocate Jenkins, you're fine?
I'm fine. I don't want to belabor the points that's been made, but I agree with the process highlighting, or what you highlight now. I think the principles that has come up through the discussion, I think there's a general consensus on that in any event. So I think it's good that we get some time to draft something, look at it, and bring it back to the committee.
I wanted to say, if ever there's no other issue about principle, let's go to the time. Let's go to the timetable, like how much time and how long is this process, so that we don't be seen by the public that we are fudging. We want to raise all these complicated things without considering that the court has already directed us that in 60 days or what, we should be able to finalize the process itself. I wanted you to put that one. It's my suggestion.
No, pick one, and to piggyback really. I wanted to recommend Section 177 of the Constitution, where the National Assembly can remove a judge, but the process happens elsewhere, not with us. Like, just also to look at different parts of our law that give us a sense of how an impeachment process should be handled. The last one is this question of 120 days. It's not in the judgment. We must disabuse ourselves with that. The judgment just said without delay. But I don't know, Chairperson, with your indulgence, I want to respectfully suggest that we must be ready. By us, I mean the entire, we must have presented the rules to Parliament and adopted end of February, so that in March, the process of impeachment can start. That's my proposal. February has 28 days, or 29, I don't know if it's leap year, but it gives us time for a draft, consultations to be adopted, then for a motion to be tabled, and then we're done. Then the country can see that we have really we have done things without delay.
I was hoping we could finalize it before the NEC tomorrow, but I suppose that was a bit optimistic. That was a light-hearted. I think that I'm very comfortable with the end of Feb, but I think we must also be realistic. And bear in mind, we may have to have a special sitting then, because we come back, 6th is the 8th, is the 8th opening. There's usually a couple of days. Then it's response to SONA, which takes over 2 days. Thereafter, almost immediately, the finance minister will want to table his budget. There's a brief period where parties get an opportunity to interrogate, then we have budget debate. There's only 28 days, so I mean, we're giving ourselves a 20-day window. So there may well be, and if that's the time frame we settle on, there may well have to be a special sitting called on one of the mornings. But we also need to bear in mind that when we finish our work, it's got to go to the Rules Committee, bearing in mind that there are parties that are not here today that are on the Rules Committee, bearing in mind that there are other parties represented in the National Assembly that are not members of either of those committees. And then, of course, it's going to have to be tabled for adoption and or debate in the NA. So, I mean, I'm comfortable with that, to have it in place by March, but I just think we must realize there's only essentially a 20-day window, and if one looks at the working days within that period, it probably starts to halve or be there and thereabouts.
But colleagues, first point is for the team to draft it as we have been agreeing on. That team generally advocate, we take about 2 weeks. Am I correct? Yeah.
I think by next week Friday we should have a draft.
By next week Friday, the draft will be ready, we'll have a draft. Simply means that the following week we must meet again as a subcommittee. And then as a subcommittee we meet, we look at the draft, and then take that draft then for your consultation purposes. And then as you agreed earlier on that the letters will be written to all parties and given the draft and look at it and have a discussion on that. The draft again is going to have options generally as we agreed, just to ensure that we don't take one point and colleagues when you go to the rules committee, people start raising other issues. I think we give them fairness on that. And then, of course, we have to give time for the Rules Committee because I think John Watt is saying February is too busy sometimes to have anything meaningful real to do because the state of the nation, all other issues there, finances. I think why can't we agree that we will try our level best to finalize this work that we are doing by the end of March? Because that will involve consultation with the parties. We are still without delays. We are doing this thing without delays. And then I think we can make it. Kubisa?
I must concur with the possible time frame. And I wanted to say, if you look at the SABC ad hoc committee, it took about 3 months or so. And then the one for the funding of political parties, it took about from June to end of November. We'll be finishing in February again, debating it. I mean, the time frame is reasonable. That time frame given by Dr. Ndlozi is somehow reasonable, but we take in cognizance what Honorable Steenhuisen is saying. I must also say, Chairperson, some of the members of this committee will be overseas this month. They come back on the 27th. So that also must be taken into cognizance. The chief whips will be in Ghana and UK, and some of them are here.
Comrades, we've got a constitutional court outcome here that we must comply with. We are talking about Ghana. No. So let me give concrete proposals. The second draft, I'm under a tree there in Mkanyawood or something.
You know, Chairperson, in Ghana's often this.
Hey. The first set of deadlines have to do with the subcommittee. And I want to argue that the only things that are in our control is really the draft of the rule. Those are the decisions of deadlines that I am concerned with. Obviously, we can think about anticipating the rest of the entire process, but it seems to me that we must have a draft rule when we separate from here on the 17th of January, I would propose, and then the final one on the 24th of January, which we then hand to everybody so that the Rules Committee can see it. Hopefully, the Rules Committee would have adopted it soon after that, but we can, if we adopted the final one and we circulate it by the 24th of January, the possibility of the National Assembly adopting it is like 14th February. And the process is still going to start, if you think about it, in March, because there must be an appointment of judges. Then we can start the process 1st of March or whatever. We're still there. But this is, on our part, what we must do without delay at this stage is a draft and adoption of a rule. And then its implementation is going to take somebody to put the motion, blah, 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 following the rules. So I propose, let's get the second draft on the 17th of February, have the final of January. 17th of January, second draft, final draft 24th of January. And then we circulate, and then hopefully we adopt it by the 14th in the House of February. It's a nice Valentine's Day gift. Thank you very much.
Stay Nathan.
Yeah, look, I mean, whether the chief whips are here or not is neither here nor there. I mean, I've got a very competent rules whip, and she's, and I know that you prefer her to being here to when I'm here. It's, but it's, so I mean, it's not, whether we're not here is neither here nor there. And I do think we should try and move it quickly. I'm just flagging that then we may need a special sitting in between the budget and SONA response to do it, because you know, those budget days and are full. I mean, SONA's a 2-day debate, and the budget as well probably be over a longer period. And I think that the SONA and the budget are to use some of the other language, are going to be lit this year. So we don't want to, but I mean, there's no reason we can't do it. But it's just going to require some specialized programming in this period.
We take the proposals, like all proposals again, because how you consult is really your business. Because you may have to consult your parties, and then whether your caucus can be convened tomorrow or not is your business to do that. And that's what we don't want to do, is to say that we are not informed that we must do 1, 2, 3, 4. Honorable Darkley, you are happy with us on that? Are you happy? I'm just worried that you are a little bit not with us. Okay. We are happy with that. Okay, we're with us. Okay. Okay, colleagues, let us then work out that way. I think it's possible for us to do so. Then we allow parties after the 24th of January, and then we allow parties to look at it. And then towards January, February, whatever, we deal with it. And then we move on that issue situation. Bearing in mind, of course, that the Rules Committee also have a right again to refer it back to us. Just don't forget that the Rules Committee have referred many other issues back to us, back to them, back to us. We'll allow that space. In reality, you may end up around April, March, and doing some of this work. But I think the work that I'm just preparing you in case, again, you revolt. That there are possibilities for that. We're saying you are very right, but we are possible also of doing that. But the point that you are raising, colleagues, is that let us do it that way. I think, Kasa, we are fine with that.
We are okay, Chair. So there is no meeting tomorrow, just to confirm that.
Yeah. It must be forward to Valentine's Day. Proper Valentine's Day gift.
Thank you very much, honorable members, for your contribution. Meeting is adjourned. Then we're going to work it out on that.